Mayor Allison Dennington. Here. Vice Mayor Sherry Corey. Here. Commissioner Corey Runty is excused absent. Commissioner Marie V. Walker. Here. Commissioner Adam Meyer.
Here.
Town Manager Elizabeth Mascaro.
Here.
Town Attorney Ryan Knight. Here. Police Chief Tim Zander.
Here.
Building Official Robert Bickgood.
Here.
Town Clerk Amber Brown is also present.
Gary, do you want to kind of maybe explain more about what a workshop is for people who haven't been here, or does that suffice?
Yeah, so the workshop it is an opportunity for the commission to actually meet and talk and discuss these issues in more detail. Usually it's just one topic, and it allows them to, and the residents to dig deeper, to ask questions. We don't have the formality that we have in a normal meeting, although there still is formality. It's a topic that usually we can't spend the time with during a regular meeting because it's something special like this. So that's really it.
So we can somewhat suspend to a certain extent some of the rules in terms of public comment. I mean, do they still have to get up and set the timer? And I've been to workshops before, but when I went to them, they were usually held over in the other room, so it doesn't have, all the formalities. But we are in here.
It's not as formal. Usually it's a time for the residents to ask questions. There's
Yeah.
not a strict minute limit. So I would welcome, even as I'm going through my presentation, anyone that has questions, just feel free to let me know.
Yeah, I mean, so I would like to maybe talk to the commissioners. Would you all be all right with if people have a question, sort of just, they don't need to get up necessarily, as long as they're if the recording equipment can get it, or do they need to get up and speak?
They would have to
need
come
to?
up to the
Okay.
microphone, name, address in order to get into the minutes.
Okay, so maybe, since there's 3 parts to the presentation, maybe if there's questions after each part, just go ahead and come on up and, come on up and raise your questions, and we'll try to address them as we go, but we're gonna try to make it not as formal as normal. But for the record and for the recording, we would need you to get up instead of ask questions from the audience. So with that said, I will turn it over.
Would you rather have me sit here or go stand at the podium?
It's up to you. Yeah. I like to pace when I'm talking and thinking, so I don't know.
I'll go up here then.
And for everybody, if you do plan on speaking, it is helpful if you sign up when she goes to do the names for the minutes later.
So thank you, Commission, Mayor, and residents for showing up. Here to talk about short-term rentals and some enforcement.
Actually, I'm so sorry, I didn't interrupt.
That was
Really
a quick
quickly,
first question.
Is this, yeah, I know, I meant to mention this. Is this recording now online and video? Okay, so the issue before with the video has been resolved, or at least temporarily. So if anyone wasn't able to come tonight, or if you want to watch it later, this actually is going to be recorded and available video, so. Sorry about that.
No problem. So my goal tonight is to really go through short-term rentals, go through your ordinance, go through some of the case laws, some of the code enforcement procedures, and try to answer any questions that you have, as well as clear up some misconceptions that I think is out there everywhere regarding short-term rentals, with every town and municipality that we represent at least. So what I'm going to do is I'm just going to start essentially going through the code and what you have now. Section 74-4 of your code provides that any violation of this chapter shall be enforced as code violations in accordance with the provisions of the Florida statutes. And just really what that means is anything that's a violation in this section should be going to a special magistrate. And I will get in a little bit later as far as what to look for and sort of how to build a successful case, because it is hard, especially with these short-term rentals and code enforcement, because of the laws and some of the due process requirements that Florida statutes do impose, especially on code enforcement officers. And, you know, often there's a perception out there, especially, you know, with residents and neighbors that, hey, this house is loud. I should be able to call the cops, and the cops can come there, bust down the door, shut down the party, tell everyone to leave, and that's the end of that. But some of the case law and some of the statutes, I'll explain why that's not the case and why code enforcement sort of has to do what they have to do and the hoops that they have to jump through in order to get to the special magistrate. First off, there's Florida Statute 509.032, which everyone in here is aware of. And that's where basically the Florida legislators said, cities, towns, you're not going to be able to regulate these short-term rentals, the Airbnbs. You're not going to be able to regulate the duration or the frequency of this. Now, prior to that, any town would have authority to come in and say, we're either going to specifically zone it a certain way to where you can't have an Airbnb. We're going to pass an ordinance saying you're not able to rent out to people for less than 7 days or whatever it was. So the legislator came in and said, nope, we're going to take that power away from you. We're going to reserve that power. And that's why cities around Florida are unable to explicitly prohibit these short-term rentals. As far as some of the code enforcement limitations, some of those, which everyone is probably familiar with, Fourth Amendment, which guarantees all persons the right to be secure from unreasonable government intrusion. One of the big cases on that was Weeks versus the United States, where the government came in, barged into someone's house, took all of his papers, all of his property, then went back, started going through it, and then charged him with a crime from the papers that they found. And that case was heavily litigated. The court said, especially when you're in your house or a residence, you have a right to privacy. The government can't just come in and, you know, bust down the doors, take all your stuff, if it's a noise complaint, whatever it is. So anything that would require going into somebody's house, and I'll sort of get into this as far as the occupancy goes and why it's so hard to enforce, is based upon the premise that people do have a right to be secure from government intrusion. And Fourth Amendment is also contained in Article 1, Section 12 of the Florida Constitution. There's also the Fifth Amendment, which is implicated especially in code enforcement cases, and that is the right to due process, procedural due process, and substantive due process. I'll get into that in a little bit as far as what is required for code enforcement and code enforcement hearings. One of the big things that code enforcement officers have to abide by is that they're not authorized to enter onto any private, commercial, or residential property to assure compliance with, or to enforce the various technical codes, or to conduct any administrative inspections or searches without the consent of the owner or operator or occupant of such premises, or without a duly issued search or administrative inspection warrant. So that's why when somebody calls code enforcement to complain about a short-term rental, code enforcement can't just go there, knock on the door and say, hey, let me look inside, let me ensure that you're complying with this.
I have a question on that,
yes.
though. Technical codes, they're not allowed to for technical codes, but what about health safety issues? Where's the distinction in line between not allowed to enter if it's a technical code violation?
But
It's my understanding like technical codes are like building code issues, whereas health and safety or nuisance issues are not technical codes. Those are historic zoning sort of police power issues.
So if there is something like that, then there would have to be a reasonable basis for the code enforcement officer to believe that there was an issue with life safety or health. Normally, that's typically, hey, I'm standing on the sidewalk, or I'm standing where I'm supposed to be. I can see, you know, this wall either falling down or this portion of the roof that's missing. It's something like
Yeah,
that.
but a nuisance is generally a misdemeanor, correct, under Florida law, which is a crime, and
It depends.
Which is
A lot of the
different.
times it's codified in
Yeah.
town codes as far as nuisances go.
yes, I am curious about that, because I've read that provision before, and about the sort of the distinction, like, is that applicable in certain circumstances that could occur if it were a really loud, noisy party where there was where's the line? So anyway, that is
Yeah,
one question.
so-
You may not have the answer right now, but I am
I mean-
curious about that.
I always look at it, if a police officer can't do it, a code enforcement officer is
Exactly.
definitely not going to be able to do it.
Yeah.
So if it's a loud party, police officer is not going to be able to necessarily enter the residence
Yeah,
and shut
but on
everything
that
down.
provision, if that's the only provision that somebody was saying, well, I can't go in or can't do anything because of that provision, then that provision only speaks to technical codes, and so that's what I'm wondering, is there any case law or
Well,
any?
There's some other case law as far as homestead residents, that's absolutely prohibited. There is an exception for administrative warrants that usually applies to commercial property,
Okay.
not residential property.
And then that
there's a whole
provision
process
also
for that.
only applies if you don't go and get an inspection warrant, so that there always is the potential to get an inspection warrant too, right?
Yes.
Okay.
So normally, especially like with Airbnbs, if you were to get an inspection warrant, you'd have to go to a judge.
Yeah.
There's certain procedures. By that time, the people are gone.
Yeah,
The violation is gone. So another provision that I wanted to talk about is anonymous complaints. So it used to be in Florida, if you had an anonymous complaint, a code enforcement officer could go to the residence and investigate that complaint. That has since changed. I believe it was a couple years ago, 2021 maybe, where the legislator did change that and said that anybody that's complaining needs to have their name and contact info in order to file that complaint and have the code inspector investigate that allegation.
that provision, though, I have read extensively too. It's got all kinds of sort of exceptions that deal with public health safety issues also. But-
Yeah, well, really,
And-
anything with code has an exception for the
Yeah.
public health, safety,
And
and life.
also, code officers are under a duty to investigate, if they see something on their own, correct? So
Yes.
even if it doesn't derive from a complaint, or if it, there's a complaint, but they don't want to leave their name, but the code, they see something on their own without going on, that would be an exception too, right?
Yes, so the way the provision reads is that a code inspector cannot basically start an investigation based upon that anonymous complaint. But, I mean, in practicality, if you get an anonymous complaint about something, I'm sure a code inspector is probably going to pass by the house or drive by the house
And
at
they-
some point in time.
And if they can see anything that they could alone, based on that evidence, use or reasonably use,
Yeah.
they don't need the complaint then? Okay. I'm
Correct.
glad we clarified.
As long as they're lawfully where they're supposed to be.
Okay,
So you
yeah.
have all these weird code enforcement
Yeah.
cases where, you have code enforcement officers pulling out ladders to peek over
Yeah, which would not be
fences
appropriate,
and stuff
'cause
like
you have a right to
that.
privacy in your
Yes.
yard, yeah. But if they're standing in the street and they're not using some camera or doing
Right.
anything, but they can clearly, okay.
Right.
Somebody does have a question.
Sure.
Particular to that,
At the-
so it was a little more informal. Particular to your discussion.
I think you have to state. your
Oh,
name
yeah.
and address.
Anne Marie McBride, 310 Second. Particular to that discussion, say I have a concern and I report it. Yeah, I'm not anonymous, but am I protected that whoever I complained against will not, or does my information become public record?
It would become public record,
Why is that I can't be protected?
because Florida sunshine laws.
Okay.
So anything that you get, it's like if you send an email to
Yes.
anybody in government, that's going to be
Yes, well, I
public record.
understand that,
So it's sort
but,
of along those lines.
Yeah.
okay.
Now, with that
And I'll get
said,
into some of the
Yeah.
evidentiary issues too, with respect to that. but-
with that said though, if for whatever reason someone did complain and there was some kind of retaliation or hostility, report that.
And really, that is one of the reasons why it is difficult to prosecute these code enforcement cases, because neighbors, they naturally don't want to really get involved. They want to report the violation, but they don't want to have to worry about anything afterwards and deal with that. So I wanted to go into parking. And Commissioner Corey brought up some very good questions in an email to me that I believe you all have that I will get to
I just got this, I haven't had a chance to read it because it showed up here.
regarding parking. So I will get to that in a second.
I do have a question.
Yes.
But it goes back to that sort of issue of, so in the case that you provided, I read it, I took a ton of notes. So I found really several things very interesting on a bunch of different issues, but they proceeded, and for you guys in the audience, this case provided, it's a pretty extensive, interesting case. It's very beginning. It is pages, let's see, 4 through 16, and the case style name is Superhost LLC versus City of Tampa. So on page 1, it says that as reflected by the documents the investigator obtained from HomeAway.com. So I'm interested to know, how did the investigator, which would be the code enforcement officer, obtain records from HomeAway.com? It doesn't say in here how they obtained it, but I'm just speculating. I would imagine that and in this case, it was also interesting. They sent the notice of violation along with the notice of hearing together, which we don't do, which I think we should, but they send it together, so it immediately goes to enforcement, right? So there's not a delay. So I suspect that what they did was they sent the notice of violation and the notice of hearing together, and then they must have sent subpoenas, administrative subpoenas to HomeAway, and that's how they got the records.
And I can tell you why there's exceptions in every code for anything that is irreparable. That was one of the issues in this
Yeah.
case, meaning, they wouldn't be able to correct it regardless, because in this case, the lacrosse team had already left.
Yeah.
So there's really nothing to cure, so.
But I mean, in terms of getting evidence or whatever, if somebody did have a complaint, there was something
Yep.
that someone saw, if we proceeded the way that they did, notice of violation together with the notice of hearing at the same time, and then immediately sent subpoenas, we would begin to have records with a case, potentially, in a given case.
You could, yes. So I think in this particular case, they sent a subpoena to the actual website to
Yeah.
get the listing and stuff like that. I don't necessarily know if they sent a subpoena. I didn't see a subpoena. I think they might have just had an investigator go on the website and pull up the listing.
Yeah,
But
okay. Well, it says they.
it is a
obtained
very
rec-
interesting case.
Yeah, it was, anyway, but, yeah.
Do you want to talk about that case?
Yeah, I mean, it was the first thing in your packet, so there was a lot of interesting, because it kind of goes through the several things, but I mean,
But doesn't that case, isn't that reflected in your presentation?
It's cited, yeah, it's sort of cited towards the end, so I can talk
no,
about
but
that
he
at the end.
didn't cover in the presentation anywhere
I was-
that issue of, well, they got records and they must have subpoenaed them, so that would be something that we could do in terms of building a case, that we probably don't currently do.
But I don't think they subpoenaed the records. I think that they probably just asked for them, which is what I'm guessing, or they were just able to go on the website and pull it up, sort of like you can do on an Airbnb and pull up, oh, someone's listing this house
I can
for
assure
7
you,
days.
I can assure
But-
you that there's no way that they got records from HomeAway.com, which is a company, without having subpoenaed them.
Well-
There's no way that Airbnb or any of those companies, but if they get a subpoena, they're gonna have to apply. I mean, that's what I'm thinking.
It depends who you talk to. I've made some
Yeah.
calls sometimes and gotten some records, other times I
Yeah.
have had to get a subpoena,
Yeah.
so it just depends. But no, it is listed, I believe towards the end of the presentation, and I can go through that then,
Yeah.
because it sort of ties due process, and some of the
But
other
we have
stuff
a
with code
provision in our
enforcement
code, and it is
altogether.
legal under law, even if you're not in a court case, but a code enforcement case, there is subpoena power.
Mm-hmm. Yeah.
Yeah. So-
Yeah. So first issue really is parking, and that's contained in 74-38. It seems like parking and noise are some of the main complaints, as from what I can tell, regarding the short-term rentals. I did review that. One of the things, and I mentioned this in the email to Mayor or to Vice Mayor Corey. There's a question regarding how do you separate parking from police citations, which are processed through the Brevard County Clerk of Court, and violations related to short-term rentals, which would be governed with a special magistrate. And the answer that I had in my response was, there really is no way. The only way, I think, in order to prosecute a parking violation through this section, would be if the police officer actually saw a person getting out from a car that was parked illegally and going into the short-term rental. Otherwise, I don't see how a police officer could know that this car parked illegally on the street is associated with this short-term rental. You could probably infer that would be the case, but I don't think, even in a quasi-judicial hearing such as code enforcement, that would be enough evidence based on its own to find somebody in violation of code. And I'll go through some of my recommendations later, but one of my recommendations is to basically put all of the parking violations under the special magistrate. And you're starting to see a lot of cities do this for a few reasons. One, they're easier to enforce, they're quicker to enforce, they're cheaper to enforce. And four, how do you think a judge in county court or any other court, when they get a case from an appeal on a $35 parking citation, is going to treat that? It's going to cost me more just to drive there and sit there for an hour to deal with that case than it would if a special magistrate were hearing 10 or 12 cases
All at one time.
on one day. And it's just more efficient for the town. Code enforcement officer only has to be there for one day to present his case. Any witnesses have to be there just for one day for their case, and not have to worry about going to court. But I will talk about that.
And for y'all in the audience, page 23 of the packet, he's got it's got our provision in the code that talks about parking, and then he's got some suggestions. And there's a 3-page question and answer that didn't make the packet, but that has some questions and answers and on the table. And you can also get a copy from Amber, our clerk, and she will put it on the website eventually as well.
So really, the first issue is how many vehicles are allowed to park in short-term rentals. And I looked through the code. I'm not sure if I missed it, but section 74-39 just says the maximum numbers of vehicles that will be allowed to park at the vacation rental must comply with sections 30-41 through 30-48. I think it would be prudent to actually list or actually say 2 or 3, whatever the commission would want to do, in order to limit the amount of vehicles that would be parked in the driveway. So that's something, when I'm looking at the code, I can't tell if 5 vehicles are allowed, if 2 vehicles are allowed. It doesn't specifically say that, and I think that's probably a big loophole, along with the split between the Brevard County courts and the special magistrate. Another thing I did want to point out, anybody that is in an Airbnb should be on notice of all of these regulations in the code, because the owner is required to provide this information to them. So if they do raise the defense that they were not aware of this particular code violation or anything like that, the owner's supposed to supply that to them. And if
Not
they
only
don't-
that, you're on notice regardless if anyone supplies
Yes.
of any
Yeah.
law, right?
But specifically this,
But yeah,
because it
but that
should
is a
be,
good point. It's double notice.
it should be attached to the agreement.
You mean the lease agreement?
Yes,
Okay, cool.
or the Airbnb
Yeah.
agreement,
Yeah.
whatever they want to say. And another reason to put parking all under the special magistrate would be the penalties for non-payment. If you have it through the special magistrate, then if it is not paid within a certain amount of time, then it can be sent to DMV. There could be a hold placed on their license, on their vehicle, in which point they're going to have to pay. So the town would have a few options. They could do that, or they could send it to a collection agency and go through there.
Another benefit of doing it through the special, like you said, it would save actually time and money. You could schedule them all together. Plus, if it's a violation at an Airbnb, these are people that are from out of town, they're vacationing, they get a ticket. I doubt they're gonna drive back down here to come and dispute the, I mean, you know, it's always possible, but they're probably just going to pay it and then post something online about how, wow, they're real tough down there in Melbourne Beach with parking, I got a ticket.
Yeah, so, you know,
So-
one thing you could do, I believe right now, the violation that I saw was like $35.
Yeah.
One thing you could do is increase that, especially with inflation. That's not what it used to be
Yes,
whenever,
it's true.
whenever that code provision was put in place.
Do you think that we could increase it, but specific to repeat violations of parking at Airbnbs, as opposed to just maybe somebody gets a second or third ticket themselves, but it's not because of an Airbnb? Would that be an equal protection issue or run afoul of the statute? Or could we sort of parcel that out and say, specific to a facility, not the same person, but, you know, you wouldn't be able to do that. You wouldn't be able to do, because it would be that person's first ticket. So that, yeah.
So
never mind.
that's a-
Answered my own question.
Yeah, so that's really another issue. Who do you cite? You know, normally you have to cite the car owner if they're parked illegally.
Yeah.
But I think at some point, especially through the code, and if you provide notice to the owner, hey, your renters or whatever you want to call them, keep doing this. You're now on notice. You either need to let them know when they move in they can't park here, document it. That way you can say we've notified you 3 or 4 times about this. And now we are going to issue you a notice of violation under our STR code.
For repeat violations.
For a repeat violation.
Huh, interesting. Can you, I know you have to give you give the ticket to the car owner, but if they're an out-of-state person, they don't pay it, can it be a lien on the property of the owner, though? Because personal jurisdiction-wise, you may not be able to, get the person who's out of state never comes back in, but
Yeah,
no.
so we wouldn't be able to put a lien on the owner's property. Probably the best recourse for that would be to send it to a collection agency.
Okay, yeah, got it.
So, if I
Oh,
may,
yes.
if you have a Airbnb host and they consistently have parking violators, and we're gonna give that host something, is that gonna come from code, or is that gonna come from the police department? And if it comes from the police department, it would still go through the magistrate, even though it is from the property perspective owner and not the violator?
Yeah, and I think it would have to be a combination of both, because when you think about it, I would imagine a lot of these are occurring at night or in the evening when people are having parties, especially on the weekends. There's not going to be a code enforcement officer that's going to be working. Normally, it'd be something if the police were to get called there for a complaint or something like that, they would be the ones who would be, actually see if there's cars parked illegally. So they would really have to be the ones to document it, just because the town doesn't have a 24/7 code enforcement officer.
So I have a question, because this is something that came up recently twice at a property that I have, my home office. There's two stretches of parking or whatever, or by the grass, and construction workers parked once, and they literally parked up and down the whole entire street and blocked access. I mean, if there was a heart attack from one of the elderly people, you wouldn't be able to get through. The police and the code enforcement, they told them, look, you cannot block up the entire street. They moved, which was great. The other one, though, was some kids parking there. I went to the neighbors and said, hey, I know if they're outsiders and they're going to the beach, I'm going to call, but I don't want to call if it's your kids. Here's my number. If it's your people, just let me know. I won't call. But if it's people that don't want to pay parking and they're just parking up and down the street, then I will. Anyway, the police came. It was a couple hours, but the police officers, they did a great job, but they were uncomfortable with, they said they could not give a ticket. Now, I have pictures that the cars were literally parked completely on the grass on my property, right? But their position, and I've looked into this a bit, is that, that they can't do anything about that. They can't write a ticket. Now, I've read the code about what parking is, and even, so my understanding, and I've researched a bit, but my understanding is, so your property that you own, right, it goes to the lot. That easement, the town doesn't own the easement. An easement is a right of use or a right of way. So you still own that area. You can park there, but other people can't. You also can put up a barrier and say, no parking, and then if you do, or you'll be towed, and then you can privately have them towed as well. And there's a provision for that. But if somebody's parked totally on the grass, which is the right of way, and someone else's property, so imagine there's an Airbnb, and they're actually parking and they're parking then on somebody else's property right next door, and the police call, and the police are saying, our own police are saying they can't do anything, they can't write a ticket, they can't force it. Can you clarify whether they can or cannot write a ticket?
I'm an attorney, so it depends on the circumstances.
Yeah.
But normally, if it is your property and you say there is a car parked on my property that is not mine,
Yeah.
then you could either have it towed or
The police can ticket?
have a citation issued.
So, because I think
They
that the
could,
police
but
don't believe they can do that.
I would leave that at the discretion of the police, and that's something that
Yeah.
I'd be happy to go through the code with them at some point and let them
Yeah.
know, this is what you can do, this is what you can't do. Because the code, got to keep in mind, it was written in, mostly 1975,
Yeah.
1995. A lot of it is sort of outdated, especially with, some of the terms that they use. And I think we would be able to go through it and define it a little better,
Yeah.
especially to give the officers
More cover.
some more guidelines.
Yes, yeah,
as
I
far as
completely
what to
understand.
look
Yeah.
for, what not to look for.
Yeah, I understand if they're unsure, but what I would like clarity on that, because other residents have had that parking issue, and they've had that same response from officers in the past. So if that is the truth, they literally cannot ticket, then, okay, but I don't know that it's true, and I'm hearing from you that they can. Enforcement discretion is another thing, but I feel like it's a bit disingenuous for the officers to say, I'm going to exercise enforcement discretion and I choose not to give them a ticket. Like, that would be an honest answer, as opposed to the statement to residents, I can't do anything, I cannot give a ticket. You either can or you can't, and if you can choose to or not choose to, but people need to be told the truth, the truth. Technically I can, I'm just not going to for these reasons. So,
Yes, like I said, I'd be happy to
yeah.
look through that, or even, just do a little memo of what to look for
Okay.
with the specific code provisions and
Yeah,
stuff
I
like
want to say, I so appreciate this, it's wonderful. It covers a lot of different topics. It's amazing. I would love to be able to have this be somewhat ongoing, if it gets updated and eventually somehow maybe turn it into a helpful handbook, so.
So with all of that discussion, 7438 specifically says, there shall be no sidewalk, on-street, right-of-way, or grass parking. So you're saying that that's inconsistent with what our normal code would be? And if so, we can't have short-term rental different than what the normal code is, so that would be the focus, and that's what you're prepared to sit down with the police chief and figure out, is that what you said?
Yeah, and I'm not
You kinda lost me a
necessarily
little
saying
bit.
that it's in conflict with the other section, but it's just sort of, this is a different mechanism. So technically, under this, if there were parking on the sidewalk or street, it would really be a code enforcement issue, because
But
that's
it
sort of-
goes back to that initial listing of questions that I don't expect someone, a police officer driving down the street or somebody walking down a street is necessarily going to understand what code that particular car should be
right.
ticketed or not ticketed
Well,
under.
I think that it is actually the same in what our code, but just, it's more clear. Because I've read that our code, so our code actually says, so it has a definition of park or parking, and it says, I'll read it. The word park or parking shall mean the standing of a vehicle, whether occupied or not, other than temporarily for the purpose of and while actually engaged in loading or unloading merchandise or passengers, as may be permitted. So basically, you're parked or you're parking. If you pull a car up, even if you're sitting in it and you're just hanging out there for a while, you're parked. You're parking. If you get out and you leave and you go do stuff, you're parked because you're not unloading and loading, right?
We're not
And hold on,
saying-
hear me out. Hear me out. No, hear me out.
We're not saying if you're parked or not.
Excuse me, please don't interrupt.
We're saying whether you're on
Excuse me,
a subject
please.
property or,
I'm not done. So that's the definition of parking. The next part is that the town has a definition of right-of-way, and the right-of-way says that that you can't park there. And that, and it also, a sidewalk under our definition of the right-of-way you could have an area that doesn't have what we all think of as a sidewalk. Basically, it's just that whole section of the right-of-way, that's grass and even no sidewalk, but it's still considered a sidewalk because of the definitions. So you can't park there and just go off. I mean, so our code could be more specific to really explain that, but if you read the various provisions of our existing code about parking, where you're allowed to park, where you're not allowed to, what the definitions of parking are, the definition of a right-of-way, the definition of a sidewalk, you get to the same place as the actual more explicit language in our short-term code. That's my opinion, but in my mind, it would probably be beneficial, though, to make that more, what's already required and prohibited, but by way of a bunch of different definitions, to maybe make it more explicit. I mean,
Yeah, like I said, I mean, one of the main issues I think is, the enforcement. If a police officer does see a car parked in front of a short-term rental, okay, should this be underneath the code violations? Should I, let the owner know that there's street parking, or should I just go ahead and write a ticket? I mean, if I got a ticket and I'm at a short-term rental, then I would argue, well, no, you can't give me a ticket because your procedure say it has to go from a special magistrate. So that's really,
yeah, but if it's just, it's just a parking violation anyway, because whether it's that or not, whether it's a short-term rental or not, if they're parked in an area that is not a legal parking spot, just happens to be an Airbnb, but they're parked there, the police can still give a ticket, whether it's an Airbnb, or they can give an actual ticket for illegal parking.
and I think that's something that I would probably add to that provision. Anybody in violation of this shall be subject to
The town code parking violation.
Yes,
tickets,
so
okay.
the $35, I believe it was, or the $100 for the subsequent violation.
Because that would give the police kind of certainty of, yeah, we can do this and we will. And I would say it would be a courtesy to knock on the door and say, listen, somebody's parked illegally there, we're gonna give you a ticket, you need to move. If they don't move, ticket.
Yeah, and it also says all vehicles utilized by the occupants. The occupants are defined as someone who is staying over. So what if it's someone who's just staying there for a few hours?
Yeah.
So I think that could also be fleshed out a little bit and clarified.
We have a question in the audience.
Yes.
Mr. Butler, would you like to come on up?
Hi, John Butler, 312 Avenue A. I'm confused. I'm sorry if I could get a little clarification. What's the issue here? Is in the ordinance, it says that the occupants have to, there shall be no sidewalk, on-street, right-of-way, or on-grass parking. Are you saying that there's no way for your officers to know if it's a short-term rental, and therefore you can't enforce anything there?
Yeah, I mean,
Is
we
that
have we have a list of short-term rentals, so they should probably carry that with them.
Is that the issue here? Because it sounds like your comment was, well, the officers can't issue a ticket for somebody parked on the right of way.
No, I believe that the officers can, but I know many residents who have been told by officers in the past and recently that the officers are under a belief that they cannot ticket. And I don't think that's correct, but I understand their hesitancy because I think that they think it's unclear, and so I think there should be clarity. And I think that goes for whether you're an Airbnb or not. I think it would go either way. However, with Airbnbs, we have a list. So if it's an unregistered Airbnb, that would be different. But we have a list of the registered Airbnbs. So if they get a call about illegal parking and they just look at the list, they would easily know, oh, well, this is an Airbnb.
Okay,
So
I'm
it could.
sorry, we've just anchored on this for a while, and
Yeah.
I'm not really quite sure what the issue is.
Yeah, so in
Is it
my
just
mind-
whether or not you know it's a code violation?
So in my
Is
mind,
that the point?
yeah, if there's an illegal if there's an illegal parking at an Airbnb, it seems to me they could get a ticket from the police for the car owner, and the Airbnb property owner could get a citation for having somebody else. I mean, it'd almost be two, a code enforcement citation and then a separate police ticket, possibly, but.
Yeah, it wouldn't be a citation, it would probably be a notice of violation through code enforcement, and documented. But really, I think the main issue is that one of these is sort of governed by the special magistrate, separate proceeding. The other one's governed by just writing a ticket, either going to court or paying it,
Okay, thank you.
if that clarifies it. Any other questions about parking?
Come on up.
I'd like to give you a scenario, if I may, and you can tell us what you think. Sure. So real quick, Mark McBride, 310 Second Avenue. So the scenario was, not too long ago, the Airbnb beside us, they had a gender reveal party, and 20 cars came to the gender reveal party. There were about 8 cars on the street, and then they were packed into the driveway and partially in the yard. So I called the police, and I said, we have an ordinance that they're not allowed to park on the street. And I don't know what happened because my cat had to leave and come back, but they were moved around a little bit. So cannot the police come at that point and knock on that door? It's obvious, they have a gender reveal party event sign in the front yard. Can they not knock on that door and say, if you have cars parked on the street, you'll need to move them? Why can't they do that? And so what could be done? And I'd like you two to answer.
Yeah, I think an experience has told us that that the officers are unsure and literally the officers told me 2 weeks ago that they cannot give a ticket. I don't think it's correct, but that is their belief. So I think some kind of discussion and actual written policy sort of clarity for when they can and can't give a ticket is in order in my mind, because clearly this is a discrepancy in terms, I think, of what the officers think they can do versus.
I think in that particular incident where there was a car parked in your yard, the officer's mentality was, it's on your property, you can have it towed if you want it towed. That was a simple fix to the problem, and that's what he thought was done. Whether if it can be ticketed or not, you're correct. He probably didn't know exactly if that particular instance could be a uniform traffic citation, could be a code violation, or what exactly it was, because it is a little ambiguous. As far as if we can walk up and see something, absolutely. But just understand that 99.9% of the time, we're going to give people the benefit of the doubt to move their car. We're not going to go ticket them right away, whether if it's an Airbnb or if it's a citizen of Melbourne Beach. We're going to go knock on the door and say, hey, your car is illegally parked. Can you please pull forward, get off the sidewalk, whatever the case may be, and give them the opportunity to do that. And what we've seen is 99.9% of the time, they move their car because they just don't know.
Well, but I was there, and the officers were amazing, and I really appreciate they handled it really well. It was specifically said to me that they said they cannot give a ticket. I don't know, I don't believe that's true, but that is what they believe, and that is what they are telling people, myself and others. So that, if that statement, they cannot give a ticket, is not true, that needs to be corrected and taught, and have something, so that they feel comfortable, because then if they give a ticket and somebody comes back later and says that you shouldn't, they are protected because they have been given advice and parameters as to when they can, and they will feel confident in being able to do it when it's necessary. In that situation, they did exactly that. They went to the homeowners, and that poor officers had to wait practically an hour for, to wake up the people, and we were 4 hours into it. And then somebody, they came onto my property and started kind of verbally, and so the officers had to then get involved and say, you can't do that. But it was a tense situation. They handled it amazingly. They were wonderful. I completely understand that their belief is they can't give a ticket. If that's not true, though, they need to be trained, and told and given tools as to when and how. And
I think, especially in that situation, with code enforcement, and it's almost like policing too. I mean, really, what you want is compliance. You don't want to be running around with code enforcement, throwing out violations to everybody. You want to make them aware of what is wrong, why it's wrong. And I think then, if you give them a warning saying, hey, you guys need to move your cars. If they don't do it an hour later, you come back, then yeah, write them a ticket.
But the thing is, police is a huge part of our budget. We have 12 officers, and parking is a huge thing when it comes to these Airbnbs. It'll be a recurring issue, where parking will be a recurring issue. We only have one code enforcement officer, but we have 12 police officers. So we have more of an opportunity for
And I think-
officers to write tickets than we do for the code enforcement.
I think really, that's where the situation comes up, which we'll talk about a little bit, how, at least have it documented so that way you notify the owner, or a procedure set up where if that's the case, then the owner of the Airbnb should be notified, because under your code, they have to make themselves available 24/7. They have to be able to come here in the event of something like that within an hour
Yeah.
and take care of it and handle it.
But can the illegal parking by someone that violates just our regular traffic code, that is one instance, the actual illegal parking, that could be a ticket, right, with the police.
Right.
And that same instance of illegal parking that happens to occur at an Airbnb is also a separate code enforcement violation. Is that possible? You could have a ticket to the car owner and a code enforcement notice to the owner for the same instance of one parking. Is that possible?
Yes.
Okay, that's what I wanted to know.
But as far as the notice of violation goes, Florida statute, you have to give an opportunity to cure.
Yes.
Unless it's repeat. So I think that's where, the documentation
Yeah, the
comes in.
documentation would be good, okay. I do feel like we have killed that,
Yeah.
but it is a sore issue with some clarity, and even the police needing clarity, so I'm glad that.
So the next issue is noise, and that's governed in 48-1 of your code. I looked through that. It has a lot of old-timey words like a phonograph being too loud, stuff like that.
And that's page 24 and 25 of his presentation in the packet, everyone.
So, obviously there's some stuff that we can go through there and pick apart and, bring it to a more modern wording. But one of the things that I looked at was the penalty there, and the penalty states any person, firm, or corporation violating any provision of this chapter shall upon conviction be punished by a fine not to exceed $200. So I don't know what upon conviction means. Does that mean you actually have to
Yeah,
write
it
them?
sounds like a criminal
Something- it
conviction.
does.
Misdemeanor, like you've taken the misdemeanor route and gone to circuit court.
It does, and a lot of the other cities too, they've sort of grouped the noise ordinance violations with the special magistrate as well.
Yeah, so that would be a recommendation,
Yeah, and that's another one. Usually when you're going to get these complaints, it's not going to be at 4 o'clock in the afternoon on a Wednesday. It's probably going to be Thursday, Friday, or Saturday night
Yeah.
when there's not a code enforcement officer
Yeah.
to be there and to document it.
Can I ask a question?
Yes.
Have you figured out with the chief your recommendations of how his officers would write a ticket after hours, and it would specify whether it's gonna go to magistrate or to the county?
No.
Have you made any recommendation upon how any of the paperwork that they're required to use through the police department, county, everything else, how that would be handled, or how that, in my mind, I'm sitting here thinking about a police officer saying, okay, which tablet should I pick out to write this ticket?
Well, I mean,
And which,
excuse me.
and which person is gonna end up ultimately handling this, because I think that's in front of an Airbnb, but I'm not sure. So should I write up a parking problem on this ticket? Or should I write it up on this ticket? So there's gonna have to be a process where everybody is on, literally, not metaphorically, the same page, that we know whether we're gonna take all traffic, parking, noise, whatever else is gonna be in that basket, and it's gonna go to the magistrate. And it's not gonna be just code enforcement, it's gonna be the police department. And so the expenses for short-term rentals are gonna have to go through a line item for the police department still and code enforcement, which is under building, I believe. And so that's gonna be a budgetary process that we have to figure out before our budget, before we even sit down with hearings. So has anybody figured out a time schedule for that, or am I the first one figuring this out? I'm not asking you, I'm asking the attorney.
I know, and I have a question too.
No, I have not spoken with Chief Zander about this. This is brand new. As far as the costs go, you know, obviously there would be more with the special magistrate if we're utilizing that more. But I have not met with Chief Zander to talk about how the citations should be written or what they should be looking for. Not yet at this point.
So I have a question.
I'm not finished. So if we have right now in our budget a $10,000 figure for magistrate, would we be able to figure out what that increase could be or should be based on the amount of money that's in our chief's budget for prosecution or whatever that line item title is, manager?
I think we could, because what I could do is I could look at other similar cities. We, you know, have Flagler Beach, which is similar in size, and see, you know, what they have budgeted, see if, what the increases were when they started doing all the parking through special magistrate, and let you know what that number is.
So if we have the opportunity to just kind of think, okay, well, the amount of Airbnbs, if you will, I think somebody threw out a number that it's 2% of our property from a tax standpoint. So then we would have to figure out a percentage of increase, could be a 2% increase in our code enforcement complete department, but I don't think 2% is enough, because right now we're spending $17,000 a year for a salary, I believe, on a code enforcement officer, and I can't for the life of me see how a code enforcement single person is gonna be able to do this for that amount of money. So I'm thinking it's gonna take probably 2.5, maybe, or at least 2, and a special computer program. Have you seen any other municipalities with a computer program that goes into the enforcement side of these Airbnbs and the magistrate in the process of keeping track? I mean, I'm looking, in my mind, based on the complaints that I've heard, I'm thinking that each Airbnb is gonna have a possibility in a month or in a year of maybe 100 code enforcement that's gonna have to go through a magistrate. So if we're looking at how many Airbnbs are we registered this year, 12 or 20, whatever it is, each one of those is gonna have 100. What is that financial picture we've got to figure out? All this is wonderful, and it really puts into perspective where our deficiencies are, but we also have to put into perspective what are the cures and how do we cover that?
So I think he said he doesn't have the numbers he will get us. That is really more of a budget issue. 2, he already confirmed that the same one parking violation, if it's at an Airbnb, can actually be 2 different issues. One could be the code enforcement violation that they could do, but the police themselves can just write a ticket for the illegal parking itself, which doesn't require us, under our current code, it would just go to county and they would have to pay the ticket. We would get part of the money. So that actually won't cost us anything. It would just be utilizing our police officers, who is a ginormous part of our budget anyway. So that's 1. 2, I would be interested to know, you did bring up a good point in the terms of what are our forms. So, I mean, the best way to figure out where your deficiencies are to just go ahead and look at what your code is and try to enforce it as it is. And then the problems are the things that you have to fix if it's difficult. So I do think having some kind of discussion and written education to the police officers, and then maybe taking some of these different provisions and creating like forms or things for the officers as well as for code enforcement on these couple specific issues. So if you get a call for illegal parking, like here's the provisions, here's the citation you would use, this is what you would check.
But you didn't read the part.
Well, I didn't get
has
it. You
been-
didn't provide it to me. I
where
got
it
it. It
has
showed up
been-
here today, so of course I didn't read it. Nobody gave it to me ahead of time.
In his PowerPoint,
I read that, but I didn't
believe-
read yours, your
I
question and
believe
answer.
that it was covered that we should put all parking citations through a magistrate, not just short-term rental. Am I
And-
correct?
Yeah, well, and that's something I'm not saying the town absolutely has to do. I'm
But
just
that
saying
was your
that is an
recommendation.
option that some other
Yeah.
towns have
And
utilized as well.
that was the example that you
But my
gave
thing
us.
my recommendation would be, we could work towards that, but right now, we need to figure out and explain to the police officers what our code actually allows and come up with a plan for how to write tickets now, and then we can decide on the other later, but we could go ahead and enforce the code now for tickets. But we have a question from the audience who has, but she's raised her hand several times, so thank you. Come on up.
Hi, I'm
Hi.
Carol Crispin, 205 Elm Avenue. I have a question that we have brought businesses into our community, and why are we discussing how Melbourne Beach would be paying for this, for any violations, any code, additional costs that is incurred by the police department or any other department? Why wouldn't we put that back onto the business that we're all having problems with to begin with? If I have to call the police, which I have had to do multiple times for loud, obscene things going on in an Airbnb behind my home, that they've graciously come out and helped me with, that why should that Airbnb owner not incur those costs? Why should I, as a Melbourne Beach taxpayer, pay for that?
Thank you.
Thank
That's a
you.
good question, yeah. And I will say that special magistrate is a cost, but when you go through the procedure, they actually have to, when you win, they pay that back. So that is borne by them
You know,
unless they appeal.
that sort of goes back to, there's a few things that you can do. It's not just increased costs with the special magistrate, it could be increased costs for the parking citation fees or fees in other areas as far as code enforcement goes or something like that, to at least try to offset that.
Yeah.
But wouldn't we have to have some formula to know what those fees should be increased by in order to
Yeah,
have
so-
those fees and not be turned down by the state?
Yes, so the fees are,
Does the state-
stated in the code, so it's something that would require an ordinance
Yeah.
amending the code.
Yeah.
Couldn't we just increase the permit? I don't know how much the permits are, but can't we increase the permits to get an Airbnb license?
Attorney,
Potentially,
would you
but there's a
like to
bill,
answer that?
it's SB 280 that's on the governor's desk that will, if it gets signed, it will actually just completely do away with our entire town registration. Except for Flagler, they get to keep theirs. It's the only one in the state that gets to, which nobody really understands.
I think they do.
I do understand, but I won't, it's politics, but.
Yeah, and that's sort of a separate issue too, as
Yeah.
far as whether we really do want to do anything right now or wait to see what
Yeah.
happens with that,
Yeah.
because it's gotta be sometime soon.
Yeah.
It's been out there for a while,
Yeah.
but hasn't been
But I
signed
will
yet.
say, our existing parking code, whether it's at an Airbnb or not, but quite frankly, most of the calls are going to be either people completely from out of town who are parking on people's streets because they don't want to pay to park, or it's going to be Airbnbs.
Yeah.
But it could apply to anyone. But if we just enforce our existing code using our police officers to actually write tickets when people are parked illegally, doesn't really matter what SB 280, whether it passes or not, we can still do that. And-
Yeah.
And we should, I think, in my mind. So I really hope that there is, in the future, more plans on clarifying that for our police officers.
Yeah. The next thought I have was really just sort of related to compliance issue with noise and,
I do have a question on noise.
Yes.
11, ours says 11 o'clock. That seems quite late to me. I know a lot of other places, it's much earlier.
yep.
Do you have any idea, you may not know now, but just what's a reasonable time that withstands scrutiny? 9 o'clock, if you do it too early, but,
I think it depends on weekdays and weekends. Weekends probably 10 o'clock.
Yeah.
I would say, weekdays, 9.
Yeah, so potentially if we were ever, that would be one area where perhaps we could, if we decided in the future to change any of this, we might want to look at making it a little bit sooner than 11 o'clock. 11 o'clock is quite late,
Yeah.
so,
Excuse me,
and,
though. Wouldn't that pertain to all family, all houses,
Yes.
all
Yeah.
residents?
yeah,
Yep.
So,
yeah. But
So
the
it
truth
wouldn't
is,
just be the
yeah.
Airbnbs, yeah.
Some, there always could be some neighbors that are gonna call in their neighbors anyway, just that live there, but, I mean, I know, usually if it's your neighbors, then they're, happen to be having a party and it's a one-off thing because their kids but it's the place next door who every day, day in, day out, and they're strangers, so. Is there an issue, do you think, the fact that we don't have a decibel limit? Because I've read cases in the past where courts will say it's void for vagueness because you lack a decibel limit. Is there in Florida?
I've seen them in some. Obviously, that's one of the issues. If you do get to a court or special magistrate, well, what's loud?
Yeah,
It's subjective.
Yeah.
So, I can tell you, in most cases, if the officer says, yes, I could hear the music as I was pulling up from a few houses away, that's probably going to be enough.
yeah,
But there is some subjectivity in there.
okay. So you think without a decibel limit, we're still okay?
Yeah, and it's not something where I would want police officers to be carrying around a decibel,
Yeah.
limit, walking around, holding it up to
Well,
see.
but if you have a decibel
But-
limit and you've got a calibrator and you go, I
If
mean, it's pretty difficult to fight that in
I-
magistrate or later to say,
It is, but I think it'd be sufficient for an officer pulling
Okay.
up. If he can hear it and is able to testify to that, then
okay,
that's
that's good.
And
That's
that's
what I was curious
sufficient.
about.
The one thing I did want to point out is on the next slide, 74-25, and that is, it's a provision in the code where the responsible party of the Airbnb, like I mentioned before, within 1 hour, must have authority to immediately address any issues concerning life safety, noise, and parking violations. So that's where that comes into play, and that's where if, we can show that they were notified, and an hour passed, nothing happened, then that's on the owner. Because under the code, they're required to basically take care of it within an hour. And then if not, they're in violation of the code. And, the next sentence there says, "A record shall be kept by the town of the complaint and the responsible party's response."
So I have a question for Police Chief Zander. Do your officers have a list of every Airbnb as well as the responsible listed party and their phone number? So that if 8 PM or 11 PM or whatever, there is a call, they're having a party and they're loud, the officer can call the responsible owner as required under our code and see if they respond within an hour so that we can document whether they did or didn't. Because under the new bill, if it passes, it will do away with our town registration, but it has a similar provision under SB 280 that likewise requires that you contact them, you contact the owner, and they have to, it's a longer period of time, but it's a short period of time. They have to respond, but the period of time starts from when you make the contact. But the thing is, if they fail to respond and you document it, you can use that to pull their license with the state for a period of time. But if we don't do that, and the officers don't have that, we're not going to be able to utilize that provision because it's a short period of time. They have to have a certain number, I need my water, a certain number of violations within a period of time. And you have to have documented that in order to be able to pull their license for multiple things. So do the officers have a list of Airbnbs and the responsible party?
We currently do not right now, no.
Can we get that for them?
Yep, we'll get with the building department and get them it would have to be updated, obviously, weekly and things
Yeah,
like that to
yeah,
make sure
yeah.
that we get that.
But I think every
We'll set up the
officer having
process.
that in the car with them or, knowing, having it would be probably helpful. And probably should be a policy that, that they would have that information available. So, okay.
Just one of the things I thought that was interesting as I was sort of looking at some of this stuff and coming across it, there's some Airbnbs that actually have noise sensors. And sort of alerts the owner or whoever it is if the house is too loud. And that's how some of the owners, because they've been getting cited for noise violations, and that's how they've been sort of proactively trying to take care of that.
Yeah.
I haven't seen it in any other city ordinance or code, but it might be something to look into.
But it'd be interesting, because if, I've read about this, and that sometimes they tried to disclaim a noise violation because they say that their meter showed that they weren't. My position would be, well, there's, that's your own meter. I mean, it could not be maybe it's not calibrated properly. It's not really sufficient, authenticated evidence that there's not a violation. You know what I mean? I mean,
Yeah, in a court of law, that would be,
Yeah.
I think, the argument during, code enforcement hearing, the
if they want to.
strict
Yeah.
rules of evidence don't apply.
But if they wanted to introduce it as a
so
defense.
they could, yeah.
We could at least say, give us your calibration records, certification, how old is it?
I hope it wouldn't get to that point for a simple noise,
Well, I think there was a case like that.
a noise violation. And then one of the issues I just put on the next slide was, some of the other cities, and this is a bigger city too, and, they have staff, they have people, but they've actually implemented a 24/7 hotline and website. I believe that was through another company. And I was actually at the code enforcement hearing speaking last week on procedural due process, but I did grab some flyers, or I was sent some flyers with some of these companies that are now offering these services. They basically track the Airbnbs. They have a 24/7 hotline where if it's too loud, instead of calling the police, you can call them, and then they actually contact the owner and document that and say, we called you at this time. So there
Well,
are
on
new
that point,
companies that
I
are
have
popping
gotten
up.
a lot of messages from some people that want to give demos for these apps. There's various apps, and they're based, you can customize them. They'll give you a whole free demo and try to come up with a package that you might want and give you a cost. But one such thing is, it's basically a resident notification app, so that if there's a violation, you can, or any complaint, you can go into the app and it documents the violations. So I would be interested in having the town admin, doing one of these demos to kind of see if there's anything that we might be able to use and what the cost would be, if any,
Yeah, it's something,
for something like that.
Yeah,
As
you'd have
opposed
to-
to a hotline, which would be expensive, but an app,
yeah.
and they're being used everywhere for lots of different things, and some of them are very small towns too, so.
Yeah, it's like anything. You have to balance the cost with the amount of complaints, and now, I'm not sure what the amount of complaints are, but, a few is probably too many, especially if you live
Yeah. Well,
next
I
door to
know
it.
people will have called, like you said, things happen at night. What happens if you call, when I've called during the daytime to the town number, it just gets routed to Brevard County, which is frustrating. But if there were an app, you wouldn't be routed to Brevard County where you're, so it would be something, I think, at least to explore and just look at. But-
So really, what I did was, I looked at the code, and it's similar to a lot of towns and municipalities and cities around Florida. So, there's really nothing that we can say, hey, we're gonna put this in here, it's gonna fix everything, because it just doesn't exist. But, I think there are a few tweaks that we could do it to at least make the code enforcement aspect a little easier for the town to enforce. The next thing I really wanted to talk about was sort of the code enforcement case, and actually what it takes to build a case, because, like I said, even before I started government law, I didn't understand what code enforcement was, or how they actually had to build a case and what they could rely on. But especially for Airbnbs, the public, and especially the neighbors, in order to build a successful case, to get from the special magistrate and impose fines, and possibly impose liens on the owner, the neighbors have to be willing to assist and provide documentation. You always see the advertisements, the Airbnbs. You can't rely on those at a code enforcement hearing. That cannot be the only thing. You can't say, well, you advertised for an Airbnb, we need to impose a lien, or we need to impose a fine on you for $250 a day. And the reason, because it's hearsay. The rules of evidence, formal rules of evidence, do not apply to the hearing, but the statutes do say the special magistrate cannot rely exclusively on that. So what else do you need? Well, you need non-hearsay evidence, and really the best way to do that is through testimony from a neighbor or somebody who actually made the complaint. And what we have been telling all of our towns, especially when we have these workshops related to this, is the best evidence that a special magistrate can see is a neighbor who is nosy. A neighbor who sits there with a notebook and says, okay, on this date I saw these cars parked here. 5 days later, I saw these cars parked there, especially if you're trying to get someone who hasn't registered. Because like I said, special magistrate can't rely on just the advertisement. There needs to be something else, and especially.
Yeah, because that's firsthand testimony, right? So it's not
That's-
hearsay, it's their first, and they've got a documented, made contemporaneously, which itself would
Yes.
be evidence, correct?
It's
Because-
firsthand
yes,
witness
contemporary, yeah.
testimony that they can also testify to.
Okay.
If they weren't willing to testify, if they just wanted to produce their records, that's not going to be enough
Yeah, 'cause they
either,
have to
because that's
authenticate
just hearsay.
Yeah.
So really, the public and the neighbors have to be involved, and either through writing it down or through photographs.
What about affidavits, sworn affidavits? Because in this case, there was a sworn affidavit. So there was a dispute, and the person that was cited, they said, oh, well, we didn't violate it because we have a lease. Here's our lease document, our proof. Our lease is for 7 days, and it says you can't have a lease less than 7 days in our lease. So they were able to win, though, the town in that case, because basically they had an affidavit from the people who rented it, and they were like, no, we only rented it for 2 days. So
That-
they had an affidavit. They could have, the defense in that case probably could have said, well, I want to cross-examine them, and if they didn't show up,
So they had an affidavit, but they also had two neighbors, I believe, who
Okay,
also
yeah.
actually
And
testified.
pictures of the giant bus and all that.
And they
yeah.
specifically mentioned that, I think, at the end of the opinion,
Yeah.
how the neighbors were willing to testify.
So
and
on
provide
that point, though, I will say
testimony.
this, we have a special magistrate, but currently, as I'm aware, and I have personal experience in the past, our town doesn't have any actual written procedures. So for Brevard, all the other places where they have a special magistrate, they have special magistrate procedures specifically, right? So that say, and they're posted, everything. Because under our town code, the special magistrate is the one who has the power to subpoena. So what happens is, so if the two parties and the defendant wants to have, call a witness, they don't have subpoena power, so they would have to go to the magistrate, and the magistrate would then subpoena whatever witness to come to the hearing. But we don't have any written policies on that, and I've said more than once, we probably should. Can you work on that? Because it is a huge problem, the fact that the only person that has subpoena power is the magistrate, and there's no procedures. We have no written procedures for anyone to actually use that. Defense or
I mean,
otherwise.
it's something that I can look at. I can tell you a lot of the codes simply will refer to Florida statute
Yeah, but like
and
Brevard
follow
County, yeah. So,
those
like,
procedures.
for example, Brevard County they've got their written procedures, so when there's a case, they track the statute and whatnot, but it basically says if you want to call a witness, this is what you do, and this is the process. We don't have that. So, in terms of building a case and evidence,
I could review it, but
Yeah.
normally it should refer back to, section 166.
yeah, but we
or-
have nothing. We don't have any
Whatever it is.
special magistrate procedures,
Okay.
so, and it has
Put
come
that on
up.
my list.
Yeah, so I would add that to the list because, that's a way somebody can even attack the entire special magistrate procedure. If you have no procedures, then the whole case could get thrown out.
Let's see. So, yeah, really just part of the code enforcement process too is the notice of violation. And, if you observe a violation one time, it's not enough to bring it from a special magistrate. Essentially, you have to show that violation has occurred 3 times. 1, to trigger the notice of violation. 2, to get the violation to the special magistrate after the notice to cure time has passed. So you've observed it twice now. And then the 3rd time would be once you actually get to the hearing and you tell the special magistrate this condition still exists. So it's not just one time. And pursuant to Florida statutes, you have to give the person a notice to cure. And that's particularly hard with a short-term rental, because you have to give them time to cure, but what are they curing? Are they curing the people who are going to leave tomorrow? And I think that's sort of where the irreparable injury comes in, that you do have in the code.
Yeah, but in this case, the court said it's not actually an irreparable injury, it doesn't qualify under that, but there's alternate grounds from which you could do the notice of violation and the notice of hearing at the same time. So it doesn't have to be irreparable harm. It was essentially just there is no cure for that type of violation, therefore there's no need to give them an opportunity to cure. Can we use that argument here? And I'll give you an example. Not a violation where it's a registered rental and it's some violation, but say it's an unregistered rental, it's totally unregistered, and they are, because we have a case, it's been like a year, I think, but they were an unregistered rental. They got a notice of violation and then it just sat for a year. In that case, because the fact that they are renting it and haven't registered at all, and they're on notice whether they knew or not, because it's the law in the town code, could that be a case where we send a notice of violation along with a notice of hearing? Because they are literally currently actually renting it, and not to, I mean, it would take a while for them to cure anyway, but people staying there at that moment is just not curable. Would that be a case where we could do those two together? Notice of violation, hearing, boom, same time.
Well, I think the violation is them not being registered, so the notice of
The
violation.
violation is they're not being registered and they're actually, it's two things, really.
Yeah,
Because
so-
there's actual people currently violating the law, and it's a safety issue because there's requirements for inspection that are applicable to rentals, and they're for safety. And so they are literally allowing people to stay in a place that has not been inspected for safety.
Yeah, so the notice of violation should have the opportunity to cure. So after that 30 days or whatever it was, 15 days was triggered, then that's something that should be brought up for a hearing from the special magistrate. And then if there are other provisions in there that they haven't complied with, such as inspections and stuff like that, they could be eligible for, $250 per fine per day. So we've had some cases where you're looking at $1,200 per day of fines being levied against this house, in which case the town would be entitled to a lien.
Do you think that there is room in our code for improvement in terms of maybe outlining things that could be considered a safety issue for which cure we deem that we don't need to give an opportunity to cure, and we could explicitly state that, so that we could speed some of these cases up without having to have it languish? Do you think there is any room in here where within the law we could clean that up?
I think it mimics sort of what is required, which is just a life safety and health issue. You don't necessarily have to go and define every one of those. It's something that the special magistrate would, have to look at.
But if we updated our code and actually said, because rentals are required to be inspected for safety, an unregistered rental that is renting, we deem it to be a safety issue, a public health and safety issue, and therefore we will treat that as an irreparable, harm to the people that would stay there, and others. And could we do that in our code? And then we wouldn't have to worry about it being a determination by the special magistrate. It would be a non-issue from the start. Yes, we could go straight forward with the notice and the hearing at the same time. Because speeding up the cases is going to be incredibly important if SB 280 passes, because you could have somebody that has repeat violations, but if you don't go from notice of violation to the end decision within a certain period of time and get a certain number within a certain period of time, you never pull their license. So the more efficient we can be is going to be hugely important if SB 280 passes. And honestly, the more efficient we could be would just be hugely important now. We shouldn't have a case that's a year in.
Yeah, I don't know the specifics of that case or what it was cited for.
They were cited for renting without being registered.
Okay, yeah.
Is that-
So,
Yeah.
I mean, it should be a 30-day to comply. If that's not the case, then send it to the special magistrate, or at least set it for a hearing, so that way you can at least start imposing fines Because especially with the new law, if it does go into effect, then in order to register the Airbnb, all liens have to be paid off through the city. So if someone's getting fined $500 a day, it adds up.
Yeah.
I have some cases where the liens are upwards of $1 million that we're trying to foreclose on now.
Yeah, and probably those places, they go quick. They track the law, you have to give a certain number of time, but they, when that time period's not, they move, they go, right? Not,
Yeah, and there sort of is a weird quirk in the Florida law where, you have to wait 90 days before you can file to foreclose on the
for the
lien.
lien. No, I'm talking about just
But-
getting to the point of getting the violation.
Yeah,
Yeah, they go quicker.
But,
Yeah.
the quirk is, some towns can, let that lien sit there for 10 years.
Yeah.
And then after 10 years, say, oh, we now want to foreclose when the fine amount is $2 million.
Yeah.
Or something
Well,
like that.
argue
So-
latches, but,
But yes, I mean, I would agree, it's better to move faster, especially with these code enforcement cases. We've talked about sort of the superhost, and in that case, part of it did get kicked back down to the special magistrate, but he did assess a $10,000 fine to start off with.
he took it seriously. They kicked
Yeah.
that back though, because basically it didn't qualify as
Well,
the irreparable part.
yes, but they really kicked it back down just to look at that $10,000 fine, because I think the attorney misclassified it as
Yes, yeah.
irreparable, and he used the wrong term for that. But if there is an ongoing violation or something like that, then there are the enhanced penalties. So that's something else.
Yeah. So, okay, go ahead, sorry.
No, that was it. I didn't know if you had any more questions of the superhost
Do-
case, because that's
Do
sort
we
of
have
where I'm
anything in
at.
our code that defines what is considered to be irreparable versus what is not necessarily considered to be irreparable, but what is considered something that, that cannot be cured? Because this is what they say. The question is whether omitting an express statement that the violations were not curable from the notice of hearing violated his due process rights. The short answer is no. And then they go on to say that this particular town, irreparable was defined as unable to return to the original condition. When a violation is not curable, giving the violator an opportunity to cure is obviously an exercise in futility. A survey of the city code, however, revealed that certain violations are expressly characterized as irreparable or reversible. Some examples, unpermitted removal of a tree, et cetera, et cetera. Ultimately, that court said that it doesn't qualify under their town's definition of irreparable, but it's still qualified as something that, while not irreparable and subject to really big fines, that it was something that was not curable, and therefore no notice and opportunity to cure was required. So that's what do we have anything in our code that defines irreparable type things, and that also defines things that may not be irreparable, but that are also not curable and not required to be given notice and opportunity to cure?
So yeah, there's not specific definitions that would classify something as irreparable
Could
or
we do that?
not curable.
Would it be beneficial to do that in terms of speeding things along and having more certainty in a hearing for the special magistrate and for the code, and then for you, who would be probably prosecuting the cases?
You certainly could. It's just one more thing to point to
Yeah.
the special magistrate, saying this
Yeah.
is defined right here, this falls squarely in right here, this is why they
Yeah.
violated.
Yeah. Do you think it would, if we had something like that, would it make cases easier?
It would certainly make cases easier. I
So-
mean, especially if you have that, just
Yeah.
like in that case. I mean, they were
Yeah.
able to point to it and say it either is or it isn't, because that's what our code
Yeah.
says. It's not
So it
open
would
to
make cases,
interpretation.
yeah, it would make the actual cases and proceeding enforcement easier, which would probably make it easier for Mr. Biggood also, if it were clear. Yeah. Okay, good to know.
Really, the last two slides are just sort of for your knowledge as far as what a notice of violation has in it. We sort of talked about it. You got to have the compliance date in the notice. That's really the main thing, because if they don't comply by that time, then it needs to be escalated to a special magistrate hearing. And then just some of the notice requirements for Florida statute 162.12, which just basically says you can't just impose a fine on somebody, there's got to be notice for that. And then really the fines slide that I have that any previous violations committed by the violator underlined, because that's one of the main things that a special magistrate will look at in assessing a fine. And it sort of goes back to section 74-25, where a record shall be kept by the town of the complaint and the responsible party's response. That's really where that would come into play, where you could show to the special magistrate, look, we've been out to this house 5 times for the same thing. We've contacted the owner 5 times. Nothing has happened. Nothing has changed. We're still having this issue. Then that gives the special magistrate a reason to levy a larger fine than probably what they should.
Do we have a process, Mr. Biggood, in terms of, for every time you communicate or whatever in a file, do you have a specific sort of record, easily accessible, of all the various times that you, or would it be something where you'd have to go and, do we have a form of each contact and response for Airbnbs? Yes. Okay, good. That's good. Because whether SB passes or not, but if it does, that's going to be a useful piece of necessary evidence.
Really, just in conclusion, like I mentioned, the town's ordinance is similar to what a lot of the towns have, and it's the same issues that a lot of the towns are experiencing. But these short-term rentals are here to stay, and there's nothing that the town can do to eliminate all the short-term rentals unless they had a previous ordinance prior to 2011, 2017, or 2016, like Flagler and some of the counties or the cities down south. So I just had some recommendations in there just based upon what was presented. I think really one of the main ones is just some kind of policy or procedure for promptly notifying the owners, because that's really where the crux of most of these cases, especially through code enforcement, are going to be, where you're showing this owner was notified, they didn't do anything. Here's our case. The other one I mentioned earlier, just limiting the number of vehicles at short-term rentals. Like to see a specific number in that as far as parking goes, and the maximum number of vehicles allowed to park there. One other consideration would be limiting the amount of people between certain hours. Some of the other municipalities have done that. That's another one too that's hard to enforce. How do you know who's in the house? How do you know who's not there? You have to look at cars. Even then, you're not going to be able to figure out. There could be 6 cars there and 6 people.
I have a question on that, though. Can you, as a town, whether SB 280 passes or not, because SB 280 has maximum numbers based on the layout of the house. There's a certain, it's 2 people per room, plus you get an extra room, whatever. Can the town at least require that they, one, they would have you would have some sort of drawing to know how many are allowed, maximum number for that place, but can they be required to show compliance by listing how many people are staying there for each rental, so that, or if an officer comes because it's believed that there's too many, that they can knock on the door and check. I mean, is there any way to do that?
Nah, I would say no. I mean, you can't get a copy of every single agreement from every Airbnb. Even if you did, people are not going to list all the people that are staying there.
Yeah.
So I think it'd really be more, a waste of the town's resources to have to go through all those, and even then, there's really not much you can do.
Until there's a shooting like there was in Jacksonville Beach, then it suddenly becomes a big deal. Sorry, go ahead.
Another recommendation, and this is all stuff, especially it's a smaller town. You got to weigh the cost and the benefit analysis of any of this stuff. But establish some kind of way for residents to report violations after hours. Like I mentioned, the parking violations to the special magistrate instead of the court, and you can also group the noise violations with that as well. And like I mentioned, this is not something I'm saying the town must do, but it's just something that I've seen some of the other towns at least implement a lot of them, especially the 24/7 hotline and stuff like that. That's just recently been implemented, so I don't know the efficiency of that or how that is working out yet, but just something to explore possibly in the future. And then, any questions? I know-
I wanted to touch upon the actual case, the dwelling, the definition of dwelling in single family.
Okay,
Because we, in our town, I did some research, I think I sent this to you a while ago, a picture of, we had pre-2011, going back to the 70s, it looks like we had in our town code actual duration limits and prohibition on
Yes.
short-term rentals. So
1975.
there's this discussion or this mantra I have heard that we didn't get in before the 2011 preemption. But I found some things in our code back in the 70s and 80s, and I don't know where it was taken out. But we did actually have a duration. We had no, it didn't say no short-term rentals, but it has, just like in this case, where it's certain things are allowed, and it says that it has the catch-all, everything else is not allowed. We still have that, but we used to have something in there where it had the zones, and it would say 1 month or more. Another area was 1 week or more, and another one had no time, so everything was prohibited.
Yes. So,
And they had a definition, we had a definition of
Yep.
dwelling and single family also. We have a definition of dwelling and single family that is similar to this, as well as provision. What we don't have is that 1 week and that 1 month minimum that we used to actually have in our code. And I want to know when were those taken out? Because if they were accidentally, through Scrivener's error, removed from our code in some, amendment of the code, but they were never actually removed, could we publish a notice to correct a Scrivener's error and put those back in our code and then enforce it?
I know R1, R2, and R3 did have restrictions where the rentals had to be 7 days or more.
Yes,
That
so-
was taking out in, I believe, December 2017, I want to say.
Are you serious?
Through an ordinance.
So basically, that is, whoa, okay, yeah.
So it was taken out, and I'm going off the top of my head, so I'm not sure the dates, but December 2017, that restriction on the 7 days or more was removed in the definition of a dwelling unit.
Was removed.
Yes, so I
So-
wouldn't anticipate that would be a Scrivener's error.
Yeah, but here's
but-
what I'm going at. The entire mantra that we didn't have a short-term rental restriction, it may not have said the word short-term rental restriction, but we literally had a short-term rental restriction just by certain terms that we could have enforced.
Through the zoning.
That go all the way back to the 70s, all the way up until 2017. So basically, after the preemption from the state, where it said if you don't have one, you can't create one. In 2007, whoever was up here in 2017 got rid of that, so now we can't put it back in, but it's gone. Like, that's very different from what has always been said.
But how was that removed? Who removed that? Did they vote on it? Like, that's
would've-
huge.
It would have had
Yes,
to
exactly,
been a
that's-
vote because it would have had to been an amendment
It
to
would
the
have been P&Z
definition
and
of
the
a
commission.
dwelling unit.
So we need
It would have
to
been
pull
P&Z and the
that.
commission both would have done that. And but we actually had a short-term rental restriction in our town code going back to the 70s, and somehow it got taken out in 2017. That is just,
Yeah, there's Attorney General opinions and stuff issued about that as far as,
but, okay, so here's why,
whether you can go back
but
and
here's what I really
pass
want to
a
make
short-term
sure,
rental.
because I have, so when I have read and listened, I literally for like almost an entire year listened, going back forever. And apparently when they did they changed the code, they revised it, it was 2014, 2017 and beyond. There are all kinds of records that go back and forth about, they had revisions and they couldn't figure out whose revisions were what, and then they couldn't find some records and papers. And anyway, the point of that being, it was a bit of a debacle. And there's real uncertainty as to who revised what and when, whether it went through the process. So if we were able to track when exactly that definition of dwelling and that 1 week and 1 month minimum got taken out or didn't manage to survive, but if it was never, that vote to take that out was never actually voted on, could it be a scrivener's error that could be corrected?
I mean, I think it'd be hard pressed to find something where something wasn't voted on, but the town clerk recorded an ordinance that was signed by the mayor. I don't see how there could be a scrivener's error
Would that be
with
negligence
something
on
like
the
that.
part of the prior attorney to have that removed and not notify people that you're taking out a short-term rental you're taking out something that once you take it out, you wouldn't be able to put it back.
I don't know, and I know especially at the time, it was not clear with respect to that and preemption and what was preempted and what was not preempted.
Well, but 2017, it was pretty clear. I mean, that basically the Florida League of Cities had been lobbying every year for however many years about the preemption, and the preemption was 2011, so 2017, that's, several years, 6 years.
Yeah, so.
Well, anyway, I'm glad you clarified that, though, because that
No, I can
is
go
what
look
I
at
thought, what I
that.
suspected, but
I can look at that because I know I've looked at the actual ordinance, but it was in
Yeah.
2017, but I don't know the ordinance
Yeah.
number offhand.
yeah. Well, I know the process when they did that was 2014 to 2017. I listened to
It's a long process.
I listened to every recording for every meeting in those years. I could not figure it out where they ever actually talked about intended, because here's what happened. It was Mr. Simmons and several other people, and they're basically, P&Z had a document, and they were making changes or whatever, and then the commission, including the mayor, had a document, and apparently there was, I could send them to the town manager or whatever, but it was like there was some missing document. They couldn't figure out there were changes that were made, but nobody, including the town clerk, could not identify or document who made the changes, but they were getting changed and incorporated, and so they had to have meetings between P&Z, and it was like, who's making these changes, whose changes are who, because they couldn't determine whether, when there were changes that were made, whether they were actually approved by P&Z, which it had to go to P&Z first, but nobody knew whose changes were, because there was, for every member on P&Z and every member on the commission, they all had individual copies of track changes, and there was nobody that was sort of making sure there was like an actual track changes copy to track them. So somewhere along that process, really important definitions and provisions were eliminated, but nobody knows who or how, I think. But had those not been eliminated, we would be able to regulate short-term rental duration.
Well,
But they were
that's-
eliminated, and so we
But
cannot.
that's my question. Would we have been able to? So is this worth investigating further? Because
So if
if
there-
we would have been able to,
So yeah, I mean, if there weren't any changes, then the way the zoning would be for R1, R2, R3, it would say that you would not be able to rent
For less than a
a
week,
dwelling
or less than
unit
a
for
month.
less than 7 days.
Yep.
And then I think R4 and R5 was a 30-day limit.
well, I guess my question is still, is it worth looking into this?
I think it's worth looking into. But we can talk about it, but I went through, that's part of the reason why I wanted copies. I printed at my own expense, like 8,000 pages, and I made binders that take up 2 things, and I have been going through them to see, they just disappear. And I can't
But you-
actually find in the record from those years where anyone intentionally took them out. They just literally go from being in it, and then it gets published later and they're not in it.
Were you, did you know about this before she just mentioned it?
I sent it to him a couple months ago.
I knew
Can I
a
just
little bit
have-
about the background,
Okay.
but
So you haven't really
I
looked into
don't
it?
know the specifics of
But you haven't
when it
really
was
looked
sent to
into it yet.
P&Z and
Okay.
when it was sent to
Okay, that's
commission
all I
track
wanted to know.
changes and all that stuff.
Okay, I just
so
didn't
no.
know if you just figured it out right now, or,
No, I sent
How?
it to him a couple months ago with, here, look at this and see what this is, like, it was just a picture. this was taken out at some point. I don't really know when, but, anyway, I will send him, there's a ton of emails, but there's about 3 or 4 emails that are really succinct on this point that I can forward to you and to the town manager, and that if we want to bring it up or discuss it, we can look into it. But
Okay,
thank you for clarifying that point.
no problem.
Would it be worthwhile for the town to hire like a forensic attorney to try? This is a really important.
Yeah, I know. Because the truth is, I believe if they never actually intended to take that out, because there are other, from the 70s forward, there's there's a ton of codes where they actually produce they publish a new, and this is in law, you generally can do this. They publish a new notice and say that certain, there was something, it was a scrivener's error, or something was just completely left out, or it was cited wrong. But sometimes it's when things are left out, you republish it to correct it, and then enforce it. And also, there is a town in South Florida that did something similar. They say, hey, if they challenge us, go ahead. They've got a lot more money. It'd be a great test case, though. It would be interesting. Yeah, I know. I mean,
Yeah,
I'd much
it's a thing.
rather,
You might have
I'd much
about-
rather them do the test case than us. But there is there's somebody else that's done something similar.
So if that were the case, you'd probably have about 26 lawsuits.
Yeah, well,
At one time.
yeah. They did it and no one's challenged them yet. It's a little, but anyway. So I think it's at least something to look into and explore. Yeah, come on up.
Rosewood Drive. Under the application process, it says that the bill allows for local governments to charge a reasonable fee for local registration and a reasonable fee to inspect a vacation rental after the registration. So I don't know what the registration fee is now, but if the local government, meaning Melbourne Beach, can determine that fee, why can't we raise that fee on the
Yeah.
people who own the rentals in order to pay for the things that you're asking the taxpayers?
Are you talking about under current law or are you talking about under SB 280?
I'm just asking about this application process.
Because I will say, under 280, they drastically cut something, basically to the point where there's so little sort of money that they drastically cut certain fees, so,
Yes, she was talking about
Yeah.
how, SB 280.
yeah.
Yeah.
So, yeah.
But I think there's actually a amount in there. So they say a reasonable fee, but I do think they have an amount.
But they're saying that the local government,
But it's
can charge.
it's a 40-page bill, though. I believe somewhere else in that there is an actual cap.
it's not
But-
something that we can decide as a town.
Well, they say
to
a
go
reason-
ahead and raise it so that
Yeah.
the people who are running these rentals
Yeah.
are incurring the cost for,
Yeah.
say, we want to have a hotline,
Yeah.
24/7 hotline.
What I'm saying is, it says reasonable cost in there. It's a 40-page bill. There's another provision somewhere in that bill where it says, and we, the legislature, deem $50 to be a reasonable cost. Yeah, like there's a,
Ridiculous, yeah.
yeah, it's a ridiculously low amount.
And
So
is that
basically, for our inspector to go out and do all of the inspection and do it properly, but then only get $50, it would be a burden financially and just in his workload. Basically it's still an important priority that we ought to do, but we
Yeah,
would be doing it with the notion that his time is being
If
expended.
this is costing
and
the
it's-
taxpayers in
we're gonna
town
run it in the
money,
red on it.
That money should be
Yeah.
put back on the people who are renting these rentals.
I absolutely agree.
Yeah,
But
but-
I would want to say, in defense of the town and Mr. Bitgood, that the legislature, if that passes, they are so severely handicapping what they deem reasonable and literally put in there
So
that,
they're specifying.
that the
even though
town
they're
could,
saying
yeah,
we
the
can-
town still could do all the inspections, but the amount of time for him to do the inspection and what the legislature is saying, here's the maximum you could get, we'd be running in the red.
Yeah.
So,
Okay, just a question.
and that you can thank your legislators for.
Is there any way to put it into the tax base, charging through taxes instead of fee?
No, taxes are very different. What you can charge in taxes are regulated under the state constitution, but also numerous laws. We have a very limited taxing authority, and it has to be evenly, the manager's much more an expert on that, but we couldn't tax them. One thing, though, I would like to, and I would like for you to read that case that I handed you. I think I've sent it to you before. Yes, come on up in a second. But we have all these exemptions for the owner occupied, and we could, in my mind, we probably ought to repeal those. But when we go to do our budget, and we do the homestead and the ad valorem and all that, we have there's an extra exemption for homestead. But if they're Airbnb-ing it, they shouldn't be getting that exemption. So how,
Yeah, they should.
yeah,
If we find that out, we turn them into the county and then they prosecute them.
okay.
Yeah, they should.
Mayor, I'd like to say something before we get
Yeah.
too far ahead. Also, why that would be a burden for the taxpayers is by state statute, building permit fees cannot in any way be used for code enforcement.
That's true, yeah.
That's actually against the law. So that would be something that definitely would fall back on the taxpayers, not on the building department, as far as I couldn't be paid to do that.
Yeah, and we have to do, there's some onerous accounting requirements for building official fees too, so, yeah.
And you know, the way I understood what Commissioner Corey was saying is, I don't think she was looking for the taxpayers to cover everything. I think that we need to be proactive and understand that all of this is going to cost us more money, regardless of whether we're able to get the money back in the future. And somehow that needs to be put into the budget. So I don't think she's really saying the taxpayers need to pay for this. I think it's just, we need to know that it's going to increase our costs, whatever it is that we do. So we need to be aware of that, everything that you're doing, yeah.
But I do, yeah.
Hopefully we'll get it later on, but I don't think that her point was taxpayers need to pay for this. We need to be aware.
But I will say this, I think the fact that we don't have a lot of Airbnbs yet is not a guarantee for the future. It very quickly could escalate, and here's a couple residents have sent me some, summer is always time when there's a lot of houses on the market. There is an actual house on the market where the realtor wrote in the write-up, not only that, but it says, and the town is very lenient on Airbnbs. That's what they said, yes, so that's what they published. So here's the thing, investors looking at that, they're reading, they're like, oh, the town's really lenient, it's a great place to Airbnb, oh, look, they have a kitchenette with a separate entrance, that's 2 units, and they're really lenient on Airbnb.
Space Coast Association of Realtors might
Exactly.
want to be made aware of
Exactly.
that.
I
They're
have
right
a
down the
little,
street.
I have a little list. I intended to call each one of those realtors and say, hey, listen, I'm not going to tell you what you do your job, but in my mind, that is a false statement. You're putting
Exactly.
a false statement in an advertisement, and I would suggest that you retract it because we are not lenient. However, with that said, let's not be lenient. Even if, in a sense, it doesn't all pay for itself, not being lenient perhaps will prevent more of them from coming, which that is something we can do. Enforce what we have and make it be known that we're not, quote unquote, really lenient on short-term rentals. So even if we don't get all the money back for it, it's,
We're gonna have to pay for it.
yeah. But, yeah. Yeah, I think with, yeah.
Don't yell at me and don't get mad at me, but can you please explain to me what you're trying to say?
Yeah.
Could you please explain to me what you mean by, I'm just saying that if he has to go out 23 times versus 1, we're going to have to pay him right now, so we need to be made aware of that. So that's all I'm trying to say. I'm not, oh my goodness, yes.
I will pull it together. Yeah,
I hope
Anne Marie
so.
McBride, 310 Second Avenue. My husband and I have been coming here since October. We've lived next to one Airbnb for 5 years. We know the stories. My husband and I have worked out a deal with the noisy one next door. We don't have to call the police every time anymore. I do not want this to happen to our community.
I don't either. That's not what I'm saying.
Sometimes, when we first came here, we were told, there's nothing you can do. So sad, too bad. There's nothing you can do. Our hands are tied. Every single one
Not
of
me.
you sitting up there, except for Adam and Ally. There's nothing we can do. The police were responsive. Thank goodness we had the police. Neighbors were responsive. And I don't mean the 3 Airbnbs next to us, but I mean our community.
I agree.
And we have to keep it, and
I
you are
agree.
part of the keepers of our community.
I agree.
Thank you.
But that's not what I.
Thank you.
That's not.
We are all paying for it. And now we hear that 2017, yes, I'm angry, and it's okay for me to be angry.
And I would be angry too, because I was not aware of this. Apparently, this came up and she sent it with, I mean,
This is shocking.
Well, I'm just
Well, I
as
was
shocked
waiting
as
for
you
this
are.
meeting to be
I
able to
am- I
discuss
live in
it.
this community. I'm just as upset as you are. I don't want to, when I say
And I
pay.
can see that now.
When I say pay, I don't mean pay. I'm just saying that I don't want us to, in our budget, not to have enough money for right now to make sure we're able
Yeah.
to cover the costs that need to be cost for enforcement. That's
Well,
what I'm talking about.
Hey, I
don't know
think,
how
I
else to say it. Maybe
as I
we
understand
need to make
budgets,
sure that we have that.
our budgets, I have a budget at home. Sometimes I go over, sometimes I
Well, we
go
need to-
under.
yeah.
And,
We need to make
if the
sure we have
town
that in
goes
there.
over, I guess we'll have to figure out some way to
But
compensate
that's
for
exactly
it.
what I was
But I
trying
have
to
a-
say.
I have a
But it
suggestion
doesn't
on
come off
that.
that way
That's-
since previous history.
That's
I mean,
what
I
was trying to
I have a
say.
suggestion on that. We are in budget season, and if it's a priority to the members up here, which it's a priority to me, and I think it's a priority to residents, that we specifically should probably consider budgeting, not just giving it to police in general, but setting up a specific fund, a short-term rental fund that is designed for housing a chunk of money that we can use for all of these sorts of things. If we need to revise town policy related to tightening up short-term rental codes, if we need to revise and work on the citations and some training for the police officers so they can be confident in what they can do, that would be for it. If we need to look into this 2017 issue and find out if there's any way we can claw that back and republish, so the budget is coming up, and that would be my suggestion, that let's designate, that would be something we could do. It's not, I mean, then we could draw from that money with specific objectives that would go potentially for code, potentially for police,
So
potentially
that's-
for legal, but
That's what I'm referring to, and I think that's what she was referring to when I said we need to make sure we have the money to pay for it. To pay, not,
When you go through the budget, the beginning of the budget hearing process is we're given all the what-ifs, what is needed, and how much that's gonna cost. If we don't have an estimate of what it's gonna cost, that's not giving us what we need to make a proper budget. And that's where I was coming from. Not to eliminate it, but we need to know what we're looking at realistically so we can get it in the budget.
And you
Period.
can imagine the people that have problems, Airbnbs next to them. We are frustrated with being kicked down the road.
yeah.
But
and
that
in our own
statement
town.
of trying to fix the budget to fix the problem is not kicking anything down the road. We're trying, my statement was, these are the factors we need to look at to figure it out. That's what we need. We've never been
And I
given any
appreciate
of
you
the
doing that.
factors to figure it out.
Well-
So now, if I may, now we've got something that we can look at that is going to give us an idea. It's gotta be categorized, gotta be line items. As far as it being a short-term rental category, it can be a byproduct of code enforcement. But when I look at the budget, I see this as code enforcement.
No, I see it as multi. I
Well,
see-
you've never done our budget.
Well-
So I think that the code enforcement
And I see
is
it-
where this money is gonna have to be set as line items. Okay, here's this code enforcement's focus, this is how much it's gonna cost us for this code enforcement officer to focus on whatever, tree trimming, whatever. This code enforcement officer is gonna have to focus on short-term rentals. And what is that gonna encompass? This part of the chief's budget, because he's got a ticket line item, this part of the chief's budget has gotta go to short-term rentals.
I would say this, I'm not comfortable at all with putting specific amounts, or saying we're gonna budget for this and just put it in code enforcement. I would only be comfortable, I mean, in my mind, this is such a unique issue, it's multifaceted, and it's, to say, create a budget that is specific to short-term rentals issues, clarification, training, any updates, code ordinances, specific amount that when there's so if it's, we're going to do some training for the police, the town attorney, that we would that we would draw from that. If there's anything left over at the end, it would just go back into general fund. But that, doing it that way would have the money available. If you put it into code enforcement, I mean, one, then it could just go to code enforcement of other things, but not short-term rentals, which doesn't do anything really on the issue, it doesn't help. So,
But you've also.
and wait, hold on, I wanted to also say this. I think what she was trying to say, I think, and don't let me put words in your mouth, but
So don't.
excuse me, I believe what she was trying to express is that they have had a very unique and frustrating issue for years. It's been difficult. And they've been told various things, that there's nothing that can be done. Then when we come to we finally have this meeting, I mean, it's like we're reviewing the code. There's a lot of interesting, things that are being discussed and some way forward. And then probably what she felt was, when the budget got brought up, it seemed maybe like a negative comment in terms of, well, we'll have to budget for us and we don't have the money. So, and I believe, I'm not done, I believe her frustration was more like, oh, here's just another way of saying we can't do anything. So,
I don't mean for you to feel that way, but if I could recite, there is a code enforcement department, and in that is a line item for training, for all of it, for the vehicle, for the gas, for everything. It's all in there. So
And since you brought up code enforcement, who is our code enforcement officer?
Jim
And
Turner.
who do I call when the garbage cans are out on the street for 2 weeks? I mean, and who
If you go to
who
our
do I call when
website-
the fence is coming down?
if you go to the website, there's a link that is code enforcement, and you just type it in, and code enforcement gets it, and they go out right away.
Yeah.
Right away.
And I didn't think you were
The
code,
link
but-
is the easiest, quickest way.
I will say real-
There is a
yeah.
record of your complaint.
But
Not
our
always. I made a complaint
frustration
online.
As
There's no record.
neighbors living next to Airbnbs, I'm not frustrated with the budget. I trust you. I may be one of the few people that do, but I trust you to make the right choices in the budget. And maybe I don't agree with you all the time, but I trust that you know the overall picture. And hearing that it's a 2% problem in Melbourne Beach is really insulting, because I have 3 right near my house. So that means I have a 75% problem in my, right at my house. I have a
that's
75, and then I have
misunderstood.
2 more on the street behind me.
And we won't be having less
And we're
Airbnbs
not gonna be
in the
having
future.
less.
We're
And I
always
don't
going to
wanna-
have more.
And I
mean,
don't
that's-
wanna wait for DeSantis to sign another bill, because apparently all we keep doing is waiting. Let's do something while we can, and I appreciate you being interested in the topic now. Thank you.
And Mr. Lebrato has been waiting very patiently, so, yes.
I saw her take
She's
that
earned
deep
the-
breath. I
She's
said, "I'm
earned the
backing
right
off."
to speak on that, yeah.
Ken Lebrato, 213 Cherry Drive. A couple of questions. First, I don't want to really get off, I think the most important thing that came out of this meeting was that the town attorney has read an ordinance that took place in December of 2017 regarding the short-term rentals that put time limitations on them for 1 week and 1 month. Is that correct?
Took out, yeah.
But you said you read the, what was it you read? Because what happens is these issues come up and everybody gets worked up about them, and then somebody changes the topic, and then we move on over here and nothing ever gets done. So I want to focus right now on this. What did you read? What did it say?
It was an ordinance from 2017 that changed the definition of a dwelling unit. And previously, the definition of that prohibited rentals for less than 7 days. The ordinance removed that 7-day provision.
And so did you also read the minutes of the meeting that removed that?
No.
No, but, yeah.
Wait, just,
Yeah.
please.
So you did not read the minutes, so you don't know who made the motion, if it was duly made, if it was seconded, and if it was passed?
No.
All you have was an ordinance that said that,
A recorded ordinance, yes.
a recorded ordinance. You're assuming that it was done properly since it was recorded.
I'm assuming because it had the proper signatures on it, but
Right,
I have
which-
not been asked to investigate it, nor have I yet at this point.
Okay, so then that was my next question. What are we doing to investigate this, to find out if the proper foundation was laid for the passing of that ordinance? What's your plan?
Well, we have a meeting tomorrow, so.
My plan is to do what the commission tells me to do.
So the reason why, one, I really wanted to have this meeting as soon as possible, because I wanted to be able to discuss this, and I would like to put specifically on an agenda, as soon as possible, a request to have this be investigated and have a vote, so it couldn't be tomorrow, but potentially it could be July. So that would be what I would like to do. Now, I may not get the votes, but that's what I would like to do. I would like that investigated. So.
Well, all right, it's a start. The second issue that is still lingering here from the previous speaker is the money issue, and the way it was carried to the people in the back, and I might have misinterpreted it, as other people may have. We can't do anything because we don't have the money.
No, no,
But,
no.
well, that's why I qualify that by
No.
saying it might have been misinterpreted.
We want to make sure
But
we have.
as I'm listening, it's, well, we need a line item, we need to know how much it's gonna cost so we can budget for it and have it accounted for. I've been at the meetings for the last 3 years. We've come up with $50,000 for a skateboard park that now got taken out. So there's $50,000 right there that was taken out of the budget that can be used for this. There was discussion about a gazebo that was
know,
gonna be
but
put
that's
at the
not what we're
pier that
saying.
was gonna cost $30,000. You people approved the Gaga pit right next door that cost a bunch of money. You spent over $80,000 on an AV system, and $180,000 that you found for an override that you fixed the project that you didn't bid on. So there is a way for you people to get money when
Yes.
you need it, and when you're committed to do something, you find the money to do it. I'm asking you, and the people here are asking you, find the money to do this.
But I think that's exactly what we're saying. We
Okay,
want
then-
to make, please.
I'm sorry,
please.
I don't-
That's exactly what I believe she was trying to say. Let's make sure we have exactly what we need to help. That's exactly what we were trying to say.
Okay.
Let's figure out, do we need $150,000? Let's find it and put it in there. We
But-
need that to make
But see,
sure we
that's,
take care of things.
and that's where I differ with you.
Okay.
Because the problem that you create is, we can't do anything until we
No.
figure out what it's gonna cost and where
disagree.
the money's coming from.
No.
And I'm telling you that I've been here at
I'm not saying
meetings
that.
where you've found the money on the spot to do a bunch of other things that cost a lot more
Yeah,
money.
well, we can't do anything on the spot today.
I'm
and
not
I-
saying
and I-
you
And
do
I
it
never
today.
said, let's not do anything. I think, I've been wanting this to be taken care of for a long time before I was on the commission. I like what we're doing here. I really like what she said about the 2017. I just want to make sure that when we are going into budget season, we make sure we have money to take care of this problem.
And my
But I'm
point
not-
is, you find money to do other things that are not in the budget, and
Mr.
when
Le-
somebody wants to put a
Okay.
skateboard park, oh, we have
Okay.
$50,000 for that. Oh, when somebody wants to put a Gaga pit, oh, we have thousands of dollars
I
for
never
that.
said we're not gonna
That's not
find
in the
money.
budget, it just appears, and it gets done.
And it will
I don't
appear
want to
this
argue it
time.
anymore. I think I
It-
agree with you
it
in
will appear.
theory, Commissioner Walker, that you want to get something done. I trust that you're being honest with the people, that you want to get it done. I wish that we had meetings like this years ago,
Yeah.
so we could have gotten farther. Enough for that. Several other points. One, that the owners, the attorney mentioned that the owners are required to notify the tenants. So what happens if the owners don't notify the tenants as to what the rules are?
And how
What
do we-
happens to the owner?
And how do we have proof that they do?
They submit a certification that I have notified each tenant that these are the rules that they have to follow. I was at the crossover at Cherry Avenue last night, and people from 204 Cherry Drive, the big blue Airbnb that I've been complaining about for months, went down there at 9 o'clock, I have pictures of it, with shovels and flashlights digging for turtles.
Oh, my God.
Okay? So how is it that they do that? And it may not be their fault if they're not from this area and aren't familiar with what goes on the coastline. But the owner of that building should be held responsible. And they're not. And it's not the first time that it's happened. And it's not the first time that I've come here and brought that issue specifically up that's by the tenants of that building.
It's a
And one thing I
certification.
just want to mention, I think I said that it was in an agreement where that should be. I believe the actual code says it should be posted.
Yeah.
inside the home.
Yeah.
According, so we do
just
have,
wanted to
when,
clarify.
if they're registered, part of that inspection is they do have a booklet there that has those rules in it. So if they're a registered Airbnb, those books are checked to make sure annually they're there. So if they were doing that, it clearly says in that book not to do that, and it lists the turtle season and all of that good stuff. At that point, the police should have been called.
Yeah, so you can lead a horse to water, but you can't make them drink. I mean, we can require them
It is
to
there.
put it in there, but we can't always make the actual lessees read it. But I think the thing was that if they get a ticket, or if they claim, oh, well, we didn't know about it, it's like, well, whether you did or you didn't, doesn't really matter.
They can't
because
claim that.
it's required, they wouldn't be able to use it as a defense, yeah.
Not for the tenants, but for the owners.
Yeah.
The problem is
Yeah.
that the owners are getting away with this.
Yeah.
The owners are not doing what they're supposed to do, and nothing happens to
Yeah.
them.
I would be curious to know if we can, as a town, require the owners, who are the lessors, they're the ones who take in the applications from people, to provide a statement, a sworn statement saying that they have checked or, they have done their due diligence and provided the necessary town information and the sex offender registry check. I don't know if we can do it or not, but I would really like to require the actual lessee, who is the one who gets the applications, to certify. I have checked the sex offender registry of the state of Florida, for everyone who rents. So that is, I don't expect you to answer that now, but
Well, the first part would be when the registration is renewed, when it's
Yeah.
going through the inspection, so you would see all that there. The second part, as far as sex offender, it's something that's very hard to track. I guess you could require a statement, but I don't know who is going to sign it and say, no, I haven't.
yeah, but if we had it part of our requirement, that I have checked, I certify under oath that I have checked and will check for all of my rentals, the sex offender, because the state law on sex offender registration is really interesting. It says that your residence is anywhere you stay for 3 days or more, and that you are required by law to register every residence and change of residence, which means if you rent a house in town for 4 days, you're required to register with the Brevard County, if you're a sex offender, that you are living there because it's 3 days. It never happens, though.
Because it's probably going to be under somebody else's name or a family member.
Well, yeah.
They're not going to put that they're staying at the Airbnb.
But, it's the person that's taking money and vetting the people that are going to stay there. In my mind, it's their duty to make sure that because they are supposed to actually check to make sure if somebody that rents it is a sex offender or not.
Yeah, and I'm guessing in a majority of those instances,
I don't think they do.
if they are checking, and they're probably just checking the name of the person.
Yeah.
I mean, they're not going to
Yeah.
inquire who all's coming over, who's staying there.
But if
So-
if they signed a certification that said, every rental last year, I checked, every adult that stays there, I run their name before renting it, to check to see if they're a registered sex offender in compliance with state law. I certify I have done that. Because there are actually cases, there's one going on right now in Orlando where somebody was a sex offender, they stayed at a place, there's several cases throughout the country, but there's people in Orlando where there was a sex offender, they didn't do any of the registration, the lessee, the person who was leasing, was supposed to, but no, they're not complying. If we could require a certification, because what happened later on, if it turns out there ever was a second, there was an act, something in town, they would be on the hook.
They're
If
gonna
they
be
didn't
liable.
actually do it, that lessee would be liable because they signed a certification saying they did, and they'd have to prove they did, and if they didn't, that's fraud.
So why don't we do that for the
Yeah.
violations that the attorney mentioned now? The noise violations, the parking violations, so that the owner of the house can be held accountable as somebody who's facilitating a nuisance
Yeah.
by allowing that to happen.
Yeah, so certifications, what kinds of certifications could we potentially require the actual rentor to do either yearly or more frequently, just basically signing certifications that they've complied with all state laws and local laws? Anyway, that would be a question.
I can look into that, but I mean, I don't know how an owner can certify that there's not going to be loud noises at the house, or that there wasn't loud
No,
noises
no,
at
no,
the
no,
house,
no, you're
or
missing the
something
point.
like that.
You're missing the point
Yeah.
again. It's not that they are gonna control the noise level, that they are notifying the tenants that you're not allowed to have noise during a certain amount of time. You're not allowed to go digging for turtles. You're not allowed to park on the sidewalks. That's the certification that I'm talking about.
And I
And
think-
why, and I don't see that that should be a big problem for the owner of the house to certify that I have got each tenant, because if you look online, they have these places booked a year in advance. It's not like somebody comes knocking on the door, I want to move in tomorrow. They have it booked for over a year in advance.
They got
So
plenty of
there's
time
no
to prepare.
problem for them to now certify that. I've notified Sally Smith and Jimmy Jones and whatever, that these are the town ordinances that apply and they are not to be violated. Because you know what's going to happen when they come in and go to court, the tenants are going to say, nobody ever told me, I didn't know that. Forget about the state ordinances, I'm talking about the state laws, the town ordinances. Nobody ever told me I can't do that, and the judge is going to say, well, if you didn't know, I'm just going to give you a warning. But now you suck in the landlord and the owner of the house, and you make them come in because they've been cited with a violation as well for maintaining a nuisance, which I believe you can do. And you get the both parties there, and nobody can point to an empty seat.
One thing we
To
can't-
play kind of devil's advocate, because so if I was renting it, and I'm not making an argument for either way, I'm just thinking as you guys are talking. So if I'm gonna make the argument as somebody who's renting it, I'm gonna say, well, I have the town license, and part of that is I had to have that book there in a common place, and if not everything, almost everything we've been talking about is in there. So my question is, so can we do both? Or eliminate the book and then make them do something every winter?
Well,
So I'm
in
just-
in this case, one of the defenses that the defense tried to use was that they said, well, we give the rules, the local town rules, and we attach it to our lease, and he introduced it, but it was a sham lease, essentially. It was like, the lease said, oh, it's 7 days or more, and then he said, but if they only stayed 2 days, that doesn't mean I violated anything, just they stayed 2 days, because my lease says 7 days. But part of the lease was, here's all the town rules, one of which was, town, you can't rent for anything less than 7 days. But it was it was a sham lease. They had an affidavit from the people.
Did it hold up?
Because the people that were staying there, they're actually not the violators, it's the homeowner or whatever. So they were like, no, we rented it for 2 days. I mean, I don't know what the lease says, but, so. But it made me think, oh, well, they've got in the lease, I wonder if that's a town requirement that, like, don't just post it, but you have to actually, when every lease provided as a copy. I don't know.
So that might be both.
Yeah, and then this way, at least if there is a court case and it comes up, they can't be going like this and say, well, it wasn't me, it was him, or vice versa.
So both.
It makes your job easier.
Yeah.
Okay, next. How many calls has the cases has a special magistrate heard in the last year? How many cases has a special magistrate heard in the last year?
You mean the last calendar year or the last 6 months, which would be 2023 to 2024 now?
Calendar year. Well, we've had the magistrate for a year, right?
But there was a break, and then ultimately became a magistrate, we had several.
Okay, so how many how many cases overall has the magistrate heard in 6 months? 4 or 5. And how many short-term rental cases have gone in the last 6 months?
Oh, really? Did you guys know that there's somebody in town that is a short-term rental place, but they're also renting their pool out by the day and by the hour, I am told. And there's also, yeah, no, people have some proof or whatever, which, I mean, I don't know if that's legal or not, but if you're renting, but like literally, there's a pool in town being rented out for daily use.
Are they camping in the backyard?
I don't know. But it does seem to be, it's like a business. I mean, like, so it's not a short-term rental. They're renting, it's a pool business. It's basically a private pool rental business. I don't know if that's,
So I mean, I wish
Yeah.
somebody would
Yeah.
tell us, because we could do that. The problem that I'm hearing from town staff and others is nobody wants to officially file a complaint because
Because
they don't
people are
want to put their
scared.
name on it.
because I think there's
And I understand that, but on the flip side to it,
Yes.
literally we can do nothing.
I know. Yeah, I mean, I think on one hand, people are scared because it's like, if you're,
I know.
even if it's not a neighbor you don't know, I mean, you don't want some retaliation. But on the other hand, I get your side too. It's like, okay, but I can't do anything if I don't have the proof.
Again, when we're driving around, like things like big boats and driveways or whatever, I can see it, I can send Jim out to take care of it or
Yeah.
whatever, and so
But there
those we're
is some
looking for.
documentation, screenshots and stuff.
But renting a pool,
So to the extent that there is a screenshot of it, they can bring it to me, and I will provide it to you.
There you go.
Because one, outside of the short-term rental issue, it does seem like that's a business, an independent business. You know what I mean? And then also, there's renting of golf carts that are associated with, but then completely not associated with the short-term rental as well. That's also, it seems to me, to be a business, which, you know,
well, I'm sure there's criteria for that.
I think that that one does that too, but the pool, I mean, just renting the pool by the hour and for the day is insane to me, and so I will give you that information, but, sorry, Ken. I don't want to forget that, it was,
Last point that I have is, you've been talking back and forth about the Senate bill that's waiting the governor's signature, and maybe you should wait to see what happens. I would advise against that. I think Mr. McBride has presented town ordinances at least twice at public meetings, right, of towns that have enacted ordinance since 2011 that we should follow, number one. And number two, you sit back and you wait, and you sit back and you wait, and then what's going to happen is they'll pass some version of it that if you don't have anything enacted, you can't act anything new, but if you have something in place, it can be grandfathered in.
Exactly.
So my advice is, do something, enact something now, and if it gets thrown out, it gets thrown out. There are other municipalities ahead of you on the chain that have enacted ordinances on short-term rentals, limiting them. They're going to go through the court system before they get to us, and you'll know what you can and can't do, number one. And number two, if the bill does get signed, it gets modified somehow, and says that if you have something in place, you're grandfathered in, we're covered. Why make the same mistake that you made before?
not only that, there's a chance even if it gets signed, there are some people who that might even challenge it, and, you know, so,
And, you know,
that's the other thing, yeah.
I'm not saying wait a year or 6 months. I anticipate a ruling to come out in a month. That's what I'm talking about, just to see. And the bill's already in its final form. It's already been passed. So
It's
there's
been-
nothing
it's
that's
been
going to be
presented now.
changed. It's either going to be signed or vetoed by Governor DeSantis.
So.
Yeah, I mean, my thinking is, let's enforce what we have and clarify, but that 2017 thing, because 280 still retains but if you have something before 2011, you get to keep it, so that,
That's all the more reason why you should have something in place now.
yeah,
Don't make the same
thank you,
mistake.
come on up.
Yes, Bruce Larson, 1507 Pine Street. Yeah, it's just July 1st. So for anybody who doesn't know, it's July 1st that bill will go into action unless there's a veto. Whether the governor signs it or it becomes law without his signature, the only choice for it to not become active is if he actively vetoes it, and he only has 2 weeks left to do it.
15 days, no signature after presentment, 15
Therefore,
days.
if we are going to do anything, we should just put a pin in it tomorrow night. Get it on the record, get it in the minutes, do something that says, here's minimally what our intention is to do. Even if you can't get it done by tomorrow night, then have a discussion, make a motion. I
Well,
mean,
we can't-
literally,
we
if
can't-
it's
We
the.
can't
if
vote
it's-
on anything in a workshop, we're prohibited.
I'm
yeah.
not saying, I'm saying do it tomorrow night.
Oh, yeah.
And put it under new business, have a discussion on it, do it earlier in the evening so that nobody has to leave before midnight or whatever.
We wouldn't
But-
be able to do that either. We'd have to call a special meeting because we can't just add things to the agenda that haven't been
Why
published.
can't we?
Agenda already has this presentation on it.
So we can bring that up.
Yeah.
No, I don't think it does.
Are you positive?
His presentation is on Robert's Rules of Order.
Well, I mean, what's the definition of new
And
business?
unfortunately, I will be finally taking a long family vacation the first 2 weeks of July. I will be here for the third week.
That's why I'm
Yeah, but-
saying that
but-
if we're going to have a discussion If we're going to do anything as a town, the only time to do something is like yesteryear. But
No,
the
not
last time we have to do
yeah.
something about it is like tomorrow.
It takes 3 months to pass any ordinance, so we could not literally pass any ordinance, even.
The ordinance is signed, and not, I'm sorry, city ordinance. I'm saying that the state ordinance, the state bill takes effect in 15 days. So why don't we just put something in meeting minutes that says we've discussed this? The town's intention is to, so at least we have a placeholder to say that we can have a next.
No, you have to have an ordinance that has been
I
passed prior. It
understand
takes
that.
3 months to pass an ordinance, so putting something, an intention to do something would not
I'm
qualify.
just trying to, well then,
Yeah.
you know, let's have a discussion on what we could do
Yeah,
then.
no, but investigating the 2017
This is my
thing,
point. If
that is because if somehow it was removed, it was never voted to be removed, and it was just a scrivener's error, it was left out completely inadvertently,
Right.
then
So
that
it's-
potentially could be corrected.
So then we
And
should
that
have
would-
that information
Yeah.
tomorrow night and discussed.
And
And that
that-
way, we could be saying, and as a follow-up,
Yeah.
our intention is to do this.
Because the correction of a scrivener's error,
Right. There you go.
it
All right.
dates back
So-
to
so-
the original
so
passage of the
please,
ordinance.
I, on behalf of the
Theoretically,
citizens
yeah.
here, please, let's research that,
Yeah.
find out, and have a discussion on it tomorrow night. If you can't bring up important business that's timely like this,
Hey.
then what's the point of having new business?
That's why
section?
I sent this to the attorney a couple months ago, and that's why I've been pushing to have this
Okay.
review of our code and be able to have a discussion about it, because I think it's worth it, and quite frankly, I don't know whether
Sure.
it would be worth it bringing it up to anybody, admin or, but
Yeah, I'm not trying to belabor anybody, I'm
but
just
I
saying,
definitely think it's
there
worth
is,
it.
there is a meeting tomorrow, and we
Yeah.
should discuss it.
Yeah, and if we discuss it tomorrow and we deem it important, we could always call a special meeting on that specific thing, emergency, to look into it as quick as possible. I mean, like, there's
Thank you.
possibilities, so.
Mark McBride, 310 Second Avenue. I want to thank you guys for being here, though, really, because we've wanted something like this for a long time, and I appreciate your patience. I also appreciate the legalese that you all were talking in, and we are all for that, work on that. From a practical standpoint, I have a question for the chief. Hey, Chief. So, you said that if your guys drove by and there's a sign out that says, an event's happening at that place, and all those cars are parked in from it, you wouldn't have any problem for your guys knocking on that door saying, hey, if you've got people in here that these are their cars, you need to have them move them now. Is that what I'm hearing?
If they're illegally parked, we would give someone the opportunity to move the cars. If they are not very friendly and they don't want to comply, then we would have the option of writing.
So would we go by illegal with all vehicles utilized by the occupants of the vacation rental must be parked in the driveway located on the subject property? Is that what we're going by?
If that's what we're going by.
That's what it says. So what do you think, Mr. Knight? Could he go and have his officers go knock on those doors and say, whoever's cars are on this street, if they're at this party, they need to be moved?
Yeah, because knocking on the door is not an
Now,
inspection.
and
If they're
I'd like to
parked
say.
illegally, then
Huh?
yes, that's what I would
Yeah, and there's
expect happen.
I'm sorry to interrupt you. There's two things happening here. One is, a lot of what happens, yes, you're the lawyer and you guys are the commissioners, you must be responsible and think about all these things. But a lot of times it's going to stop, as Chief knows. It'll stop as soon as those people will move those cars. Right then and there, they'll do something. And so the question is that I wanted to make clear is that if that happens again, and it happened just the other day, when was it, Anne Marie? It was last week, the other Airbnb on our street, they were parked on the street and in the lawn of the Airbnb, about 10 or 12 cars. I wonder if they're in their own lawn, it's the lawn of the Airbnb, it's on the side of, on the easement property, can you ask them to move those cars? Can you go knock on the door and say, we have an ordinance that you're not allowed to park
Well,
illegally?
I think if it's their own house.
It's not, it's
No,
the
and here's what I'm
Airbnb.
saying.
They're-
This is why I think that distinction that I
Right.
tried to get the town attorney to sort of talk about is incredibly important. We have a code that says that you can't park in the right of
Right.
way, but if it's your own property, you own it. So, but if it's somebody else's property, so you could cite them, whether it's an Airbnb or not, the police, but the police need to know that they can
Right.
do that.
So-
But then the other thing is, if it's not the guest's property, it's a Airbnb, and our Airbnb specific says not only can you not park in the grass and all that.
That's
but
right.
You actually have to be parked like in a driveway itself.
That's what it
So
says.
that part would be the potentially, the ticketing the cars, plus the second for the same exact car, the Airbnb violation.
The occupants must be parked within a driveway located on the property.
Do they have to provide?
There shall be, let me just finish if I may, there shall be no sidewalk, on-street right-of-way, or grass parking. So with that, if we had called on them, would you have been able to come over and knock and say, hey, you're going against one of our ordinances, you're going to have to get these people to move? Now, they may challenge you, and then we're into law. But up until that moment, they may move, wouldn't they? And so the question is, would your guys do that?
Yes.
So there you go. Now, this is important because we need to know, just on a street level, of what we can do and what we can't do. Now, there's another thing that's happening. There's the occupancy. As you, Mr. Knight, you noted that our ordinances say 12 occupants, right? So when they drove by, when I had the police come, and there were 20 cars at that place, and there were about 35 people outside, did they have the right of that Airbnb to say, you need to clear this party, you need to clear this property?
I would say no, because if you look at the town code, an occupant is described as someone who occupies a vacation rental overnight.
So that needs to be changed. If that were, again, if you were making changes and this new thing that the governor's doing doesn't pass, this new bill doesn't pass, that could be changed, could it not? So that it, so.
I actually think SB 280 does define occupant more stringently, so that is one.
Well,
good
okay,
thing.
but I'm just saying if it doesn't pass, could that be changed so that there's only 12 occupants? Because you're also talking about changing a rehab. I showed you Cocoa Beach's ordinance where you're only allowed 4 vehicles on property. So,
Well, more importantly, though, this is what I would say. To the extent that SB 280 actually does make some more stringent requirements, those would be things that we could track and do ourselves, because if SB 280 passes and whatever we did goes out the window, but that's fine, because it's not wasted, because we track the language anyway, the actual parts of SB 280 that were more restrictive. If for whatever reason it doesn't pass, well, we went ahead and added those more restrictive provisions anyway. So it's sort of a efficient use of a change.
Yeah.
Does that make sense?
It does. Assuming it doesn't pass, I'm not sure you could change the definition of an occupant. To me, an occupant is, there's sort of a difference between an occupant and a guest. So I'm not sure how much you could change the definition of that, but
Can you add that to your
I
sort
would
of
think there would
action?
be something, you could sort of tighten down or even limit the amount of guests or whatever
Yeah.
that's allowed at a short-term
right,
rental at
so,
one time.
so I appreciate that. And so, Chief, I guess we got our answer. If you drive by and there's 40 people in that yard, you can't really say anything about occupancy.
We can always ask. We can always ask them to move their thing.
Yeah.
Well,
Well,
the vehicles are separate. The vehicles is a done
mean
deal.
occupancy.
I'm talking occupancy now.
Yeah.
Okay, so, the new, if the new bill passes, it passes, and that's it, it's done. But the reality is that right now, it hasn't passed. And what might come back is he might come back and say, I veto it, I want some changes. It might be kicked down the road, and my wife was talking about kicking down the road. We don't have control of that bill. We can vote for governors who maybe would not be for this, and legislatures, but we do have control at the moment anyway, at the moment of our ordinances. And so, Mr. Knight, I gave you that copy of the July 23 Cocoa Beach short rental ordinances. That had in there about of the 4 vehicles, of the vacation rentals, et cetera. And I also gave you, on that was a copy of the Reddington Beach. That was December 22. Now, I'm assuming that those haven't been challenged, because I think you maybe would have mentioned it.
I spoke to Reddington Beach Mayor. He said that they have not been challenged and they've been very successful.
And those are much, much tighter than what we have. So, for example, there are 9 p.m. cutoffs. There's no amplified music. They're much tighter. And so why not, why not write them up? And
Because
friend
that-
here
yeah.
wants to do it immediately. I know, I've learned from you guys, you can't do anything immediately. But why not do it? Why not? And so if you want to wait till July 1st or 4th or whenever it was and see if that bill, if he doesn't, and it comes into, then we know it doesn't matter. It's out the door.
No, but the
if-
noise thing we could change. I mean, we
But,
could,
well, whatever we can still control, we should control. And so their noise thing is very important. So what we did is we spent about $20,000 and we bought hurricane windows for our house. And we did that to stop some of the noise, and it stopped about 60%. Since we've had the windows, as Anne Marie said, we've been in contact with the owner, and we've called them 4 times complaining about noise. I have videos and recordings. I'm sure you've heard them before. And so that's helped, but we still hear it, right? Their noise thing that they have, Coco has, and it says if the windows and doors are closed, then it's audible within the house. So like when we're watching our television, instead of us having to turn on a white sound device and then turn the TV up to 50, I could call the police. And that's another thing that I think we need to make it very clear. In the law, it might be that it needs to be it could be a quiet time at 9, according to their ordinances. But you can call the police anytime, that if you're in your house and you're being disturbed, you can call them. And you can call them at 3 in the morning and it'll go into town, but they'll still be here. And we're really fortunate, right? Because the South Beaches, as your wife knows, they don't have that, right? They're screwed. We have a chief. We have these officers. We're so fortunate, right? So we need to know that, though, right? And you would agree, right? If I called you at 2 o'clock in the afternoon, and I said, these people have been carrying on for an hour in my backyard, and I'm in the middle of my house, I hear them. You're going to come out and knock on their door, aren't you? And you're going to ask them. Now, legally, I don't know what you can enforce, but 10 to 1, they're going to stop, right?
so I do have a question for the chief, though. If a resident calls about a bunch of cars parking, the police come out, and the police tell the resident, like they told me, we can't give a ticket. But you're saying, the town attorney's saying they can, and you're saying that they can and should. What is their recourse? Or could, but if the police officer, hypothetically says, I'm going to choose not to give a ticket in this circumstance. I could give them a ticket, but I'm going to choose not to. I'm going to exercise discretion. He doesn't say that. He says, I'm sorry, but I don't have authority. I cannot give a ticket.
Right.
Which is not correct.
Correct.
What is their recourse? Do they call you and say, so-and-so told me that they believe they can't give a ticket?
Absolutely. There's
Okay.
always a supervisor working, so they can always call back and say, I would like to speak to a supervisor.
Yeah, okay.
The
So,
supervisor will come out and deal with the issue.
okay, good. So, and you'll be able to kind of relay that down in conjunction with the town attorney on that sort of parking issue? Great, wonderful, thank you. All right.
Hi, my name is Charles Lutz, 212 Cherry Drive. I have a question for council. My question is, you mentioned the special magistrate pays particular attention to testimony typically provided by neighbors in a situation like that, correct? Council?
Yes, sir.
If that testimony were instead to come from another town citizen, so if you have a citizen that is willing to put themselves out there to go collect evidence, as an example, all the cars that are parked illegally, take photographic evidence, and be willing to provide testimony, in your opinion, would a special magistrate give that testimony credence?
So if you were the citizen, you would have to be the one taking the photographs. You wouldn't be able to collect it from other people and then introduce it, because that would also be hearsay.
No, but again, so let's just say it was me. If neighbor 3 doors down had issues with, let's call it a short-term rental that was causing them problems, they were unwilling to confront, but they outsourced that to me, and I were to take photographic evidence as an example of parking, and I were willing to testify.
Yes, that would be.
Yeah.
In
It'd
your
be fine.
opinion, that would be credible for the special
If
magistrate?
you're the one taking the pictures, if you're the one testifying, if you're the one who witnessed it and saw it, then yes, that's.
Not only would be credible,
It's
the
contested.
more important thing is the fact that the state law says that the magistrate cannot issue an order that relies on hearsay alone. So in order to have he would have to have something other than hearsay. So he not only would consider it and be able to consider it, but he would be able to then reach a judgment and use that as the basis, because it's not hearsay. which would be a supportable judgment later.
And have you had any experience with other towns where you've had groups of citizens perform that kind of a role?
Neighborhood watch.
Not necessarily like a group of citizens, it's always just sort of been neighbors. So we've never had, one person organize and sort of, go out and try to take pictures for everybody. It's really just always been.
I will say
the neighbors.
there's a very interesting provision in Florida law that you can form a neighborhood watch group. Neighborhood watches, they're common everywhere. There's actually some interesting provisions in state law that if you form a neighborhood watch group, you actually get some protections for doing that kind of thing, almost more protections than the building official has. So for sort of documenting and reporting that kind of stuff, there are protections under state law. So if neighborhood group wanted to form a neighborhood association, they would be able to do that, and it would probably be an effective thing that would save Mr. Bitt good time and money.
If I'm hearing you, I think the base of your question is, does it have to be a resident that is witnessing the violations? Is that kind of where you're coming from?
So
If
my
you're
point
visiting
was simply,
somebody-
my question was, did it have to be an immediately adjacent neighbor who's being impacted, or could it be a proxy who is still a resident?
Yeah.
Or even not?
It doesn't even have to be a resident. The thing is, it has to be non-hearsay. I mean,
Right.
I'm sorry, this is,
It
it's
doesn't
hard
have to be a resident, you don't have to reside right next to the property, you could reside on the other side of town. if you
It has
have-
to be firsthand knowledge, and then if there's a picture, you'd have to be able to authenticate it. So you couldn't be like, somebody else took this picture and I got it. You would have had to take the picture
It's-
and then testify.
Yeah, and so you could say, on Saturday night at 10, I took this picture of all these cars parked right here.
Right.
And it doesn't
Whatever
matter
it
where
is.
you live. The defense might say, yeah, but that guy's a vigilante, that's what he does. So they could try to attack someone's credibility based on, like, you have an agenda, but that would be an issue of weight. It would be admissible evidence from which the special magistrate can legally base a decision, without which he can't base a decision.
Yeah, clearly you would have an agenda
Yeah.
if you were doing that.
Yeah.
And the agenda would be protecting your community.
Exactly. No, exactly, yeah.
And that's why, that's why really the more information you have, if you have that on top of, hey, these last 3 times, the owner was notified, they still haven't, still haven't done this, still haven't corrected this, we now have videos were taken on this day, or pictures were taken on this day, that's a lot of evidence that the special magistrate is going to give weight to.
Yep. Yeah. So, I think, I would like to propose that this be an ongoing process, not every month necessarily, but I really want to thank you so much for the time and the effort, and then coming over here. It's great, and I would love personally, and we'll try to bring it up eventually for the commission, but for us to keep going with this, come up with some action items on potential things that you recommended, exploring those, but also potentially turning this into a handbook for residents. So I don't know if we have any more questions. I know it is getting late, but I want to thank you very much. Really appreciate it. I think you did a great
No
job.
problem, thank you for having me.
So, do we have any more questions?
Just thank you for putting this together.
Okay, thank you. Thank you, Mr. Knight, very much. So do we have a motion to adjourn? Second. Okay, that was Vice Mayor Corey did the motion, and Commissioner Walker seconded. All in favor, say aye. Aye, that's 4-0.